Yes, Mr. Sen.
Your Lordships. My Lord, I seek your Lordship permission to move a urgent unlisted matter.
Regarding?
My Lord, this is pertaining to a transfer matter, your Lordships.
Transfer was urgency in transfer.
My Lord, there is urgency. I have been used to, what happened, your Lordships? I am about to retire, barely 30 days left of my retirement from school. When I am expecting my farewell, your Lordships, at this juncture, my Lord, I have been transferred out, that to a post, my Lord, ex-cadre post. This is, my Lord, partly illegal, your Lordships. And now this is creating a lot of confusions.
No, what's the urgency? They will come tomorrow.
My Lord, urgency is in the sense, my Lord, this order has been served day before yesterday on me, your Lordships. And now there is a direction to the order to the assistant vice principal, your Lordship, vice principal.
No, but is there any proceedings pending or something?
No, my Lord, I'll satisfy. Nothing is.
What is there then?
They are saying public interest. My Lord, what kind of public interest, your Lordship? No public interest at all.
Transfer course don't normally.
It's not in normal course, your Lordship. They are saying public interest.
Penal in nature?
Lordship?
Is it penal in nature? What is
so far the contents of the order is concerned, my Lord, it is not penal. They are saying simply public interest. But if your Lordship look into entire facts and situation, it seems, my Lord, they are punishing me without holding any inquiry, no disciplinary proceeding pending, my Lord, nothing. Can they do it like this? And I am about to retire, my Lord, on 31st, my Lord, July. When I am, my Lord, planning my retirement, my Lord, this is happening. So, my Lord, there is some confusion because, my Lord, there is an order to the vice principal to take over the charge.
Has been filed?
Yes, my Lord.
Okay. You give notice to the state?
Yes, I'll publish.
Why retiring on 31st? If not penal in nature,
not
why?
Penal, my Lord. That is what is shocking, your Lordship. Had it been penal, my Lord, it would have been otherwise. I would have been required to challenge all those proceedings. Nothing. Nothing at all, my Lord. This is very unfortunate what is happening, your Lordship. Very, very unfortunate.
Okay.
Any mention?
Your Lordship, I beg item number 16, Your Lordship.
You beg item number 16?
Yes, that matter will be taken after 2 weeks, Your Lordship.
My Lord, I appear for the state respondents.
Wait, 2 weeks, yes.
Right.
Please, Lordship, I beg to mention item number 21, Lordship. The learned counsel for the petitioner, Mr. J. Sheila, is currently out of station. Lordship, therefore, I pray for 2 weeks' time.
Yes, Mr. Shulai?
Lordship, no objection.
2 weeks, yes.
Similar prayer for item number 22, Lordship.
On whose behalf?
On Mr. Sheikh, Mr. S. A. Sheikh.
Mr.?
S. A. Sheikh.
You're who's junior?
S. A. Sheikh.
Whose junior are you?
S. A. Sheikh.
S. A. Sheikh, then you're a professional mentioner for different councils. Yes.
Highly obliged, Lordship.
Highly obliged.
My Lord, item number 13, wherein Jindal Sahib is also appearing, my Lord.
Please come forward. Yes.
It is a good news for us, my Lord, that the parties are going to compromise. So we need some time to make the settlement, and my Lord. Item number 13, my Lord.
Let's see if it materialize for weeks.
Among brothers, I think you should compromise.
Yes, my Lord, it is amongst the brothers.
That's yes. The council for the party submit that the instant matters. You think settlement talks are going on?
Settlement is going on, yet to be finalized, my Lord.
Yes, that settlement talks have been going on, and the matters to be likely to be settled out of court. Accordingly, the period of the matter be listed after 4 weeks. On the period of the councils, this is a matter of 4 weeks. Yes. Yes.
May I be pleased, Lordship? I beg to mention my item number 20. Something for 3 weeks' time.
20?
Respondent number 1 and 2.
Question for the petitioner.
You with Mr. Manta?
Yes.
Where's Mr. Manta? Is recovered now?
Not fully, Your Lordship.
Okay, 3 weeks. On account of as the senior counsel for respondents still to be indisposed. Yes.
Obliged.
Supplementary list, item number 1.
Please, Your Lordship. Your Lordship, here the petitioner is the brother of the deceased who was killed in a police encounter. That was nearly 2 years ago. The government had constituted a one-man inquiry, and Learned retired Justice Vaipai, commissioner in that inquiry, and short of holding that the police had murdered my brother, has said that they have killed him. So this is 2 years has elapsed, my lord.
Who said it's killed him? Report.
Even the inquiry report. So prima facie, it was the police who had killed my brother. So, my lord, now we had filed an FIR also. That was way back on 18/8. But till date, the state respondents have yet to do anything in respect to this matter.
Where's the FIR? I mean, it's done anything meaning? But inquiry was done.
Inquiry was done.
But no response was fixed.
No. According to my knowledge, no responsibility was fixed. And even the criminal case.
Because the thing is that inquiry, okay, it is not.
Yes.
Cannot be implemented. It's only recommendations.
In fact, Your Lordship will just come to page 49. That's what the inquiry was. Page 49, my lord. Paragraph 35.
Para?
35, last para.
Yes, both the
learned counsels appearing for the state and the family of the victim submitted their respective written arguments, which are annexed hereto as Annexion 9 and 10 respectively, and raised a number of contentions to support the respective cases. But as already observed by me elsewhere, I do not propose to burden this report with such contentions in view of my above findings. For example, I do not propose to discuss the other evidence available on record to determine as to whether witness number 4 mouthed down the deceased intentionally or in self-defense, since the materials I could derive from the statements of the 3 state witnesses are sufficient for me to arrive at my above findings about the culpability of the tactical team number 1 in the manner in which they carried out the operation. The remaining issues are best left to the jurisdictional criminal court to decide. Now, the least we expect as a family is that the criminal case should be.
What is the status now?
We have no idea.
What do you want by this petition?
By this petition, we want that the CBI inquiry should be sent to
CBI
the
inquiry?
CBI. Yes. Because here, my lord, the police are involved, high police officials are involved. The tactical team was led by the SP, 2 SPs in fact.
You want inquiry or prosecution
prosecution by the CBI. Because till date,
for the respondent.
Yeah.
Yes, Mr. Said. One second. Let me just finish with the petitioner first.
Yes.
Where's the FIR? It was registered on?
It was registered on FIR, my lord, is at page 18.
So what? Just the date?
Page 18.
Inquiry?
18/8.
On?
18/8/2021 was the FIR.
18/20. When was the report? The inquiry report?
The inquiry report. Yeah, inquiry.
It was. The inquiry report was ready and submitted on
19th May 2022.
19th May.
19/5/22.
Yes. Well, the family members have been running from pillar to post to find out as to what has happened to the.
Yes, Mr. Sai. Yes.
Two aspects of the matter. Firstly, the inquiry report has not returned any findings stating that the deceased was in fact killed by the police as has been characterized by the petitioner. That's number one. Number two, the inquiry report gave detailed recommendations. On those recommendations, certain actions have been instituted departmentally by the government. That will have to be perhaps brought on record. But
you have to bring the status report of the at this stage, Mr.
That will be done.
Yes.
Only two aspects of the matter.
Yes.
Lordship will notice that this is a case that has been filed nearly 2 years plus after the incident. There is no quarrel.
No, that will look into it. The only thing is that whatever it is, they have their own grievances. They have a right to know also. Right to know about what's happened to the, if there are some recommendations, as he has shown that
that is not
culpability of whatever this. tactical team or something.
Their prayer here is for a CBI inquiry. I'm only on the limited prayer
No,
here.
coming to CBI is a different
That-
matter.
that-
At least we have to be satisfied that if there's been, total inaction or total disregard. Yes, heard Mr. T.
Lordship, I quite-
Yes, we heard Mr. T. Dingdo, Senior Counsel, assisted by Mr. Arkas Art for the petitioner. If you notice, Mr. S. Sahai, with whom?
E.R. Khain.
Lordship,
Mr.
Mr.
Khan's present on behalf of all the respondents, no further notice. All the respondents? All the respondents?
Yes.
No further notice
Yes,
called
yes.
for, yes. The next paragraph, the grievance of the writ petitioner, as can be made out in the prayer. The grievance of writ petitioner is that after the FIR had been filed on 18/8/2021 and a case registered being, what's the case number? A Mola IPS case number 44 of 2021, and also an inquiry report dated 19/5/2022 submitted to the authorities. The writ petitioner and the family are not aware as to what has transpired thereafter. Stop. Therefore, prays appropriate orders be passed for the investigation. No, forget that. It's right after that. Stop. Next paragraph, Ms. S. Sahai, on behalf of the respondents, submits that certain steps have been taken insofar as investigation and action against the errant personnel are concerned. Stop. He prays and is allowed to bring the status report and other materials by way of affidavit in a period of 4 weeks from now.
Much good.
Just after 4 weeks and so. You file an affidavit.
Main list, item number 1.
Your Lordship, if this matter can come up after 1 week, Your Lordship, as the leading counsel is indisposed, Your Lordship.
I think we have to rehear the matter.
Yes, Lordship. This whole matter has to be heard again, freshman.
Because anyway, as the counsel is responsibly indisposed, this is a matter after 1 week for admission hearing.
Yes.
Much obliged.
We'll try to finish up the hearing dispose next week.
Yes.
Item number 2.
After 1 week time for rejoinder.
How many times you ask for rejoinder?
Two times, Lordship. 3 times.
3 times you ask.
2 times.
Sure.
2 times.
Sure. Otherwise, you want to pay cost. If it's a 4th time asking.
2 times. This will be my 3rd time, Lordship. Today.
The 3rd and final time.
3rd and final time.
Yes. Mr. No objection. Yes, further 2 weeks time granted as prayed for general affidavit. Well, not recording the orders, but I've go on 3 times.
File it.
Rejoinder is not by right, yes.
Item number 3.
I am appearing for the respondent number 3. Your Lordship, the relevant application under Order 7, Rule 11, we will be filing it today during the course of the day, Your Lordship.
Lordship already filed. So I've received a copy of an application, my lord.
This is regarding Bagmara?
This is regarding Bagmara.
The 9A?
Yes, my lord.
Number 3 is that return candidate?
Yes, my lord.
Please, Your Lordship.
Bagmara is?
They've just filed it. They have served me a copy. I need 2 weeks' time to file a reply on this, my lord.
Why take 2 weeks' time? File in 1 week, 1 week after you'll dispose it of.
Let it be 10 days, my lord. Let it be 10 days. Let it be 10 days, my lord. They have also filed an application, my lord. They have also taken lots of time. And they have just served me. I need to complete the instruction also. I have to call the petitioner.
I understand. Anyway. We'll give you 3 weeks.
No, not 3 weeks, my lord. 2 weeks.
I don't want counsel to ask for more time later on again.
No, I'm not going to ask, my lord. I will make sure that I file it, my lord.
Yes, Or you find a 7 Rule 11. Yes, application on behalf of respondent number 3 under Order 7 Rule 11 has been filed by the respondent number 3, and the same is taken on board. Stop. Mr. SD, on behalf of that paragraph, is on behalf of the petitioner, please be allowed 3 weeks time.
2 weeks.
2 weeks time to file reply. This up to 2 weeks.
Hello.
Deeply obliged, Your Lordship.
Item number 4.
Before I appear for the return candidate, we've also filed an application under Order 7 Rule 11, read with Section
Have you received copy?
86.
Yes, Lordship received.
You want to file a reply to that?
Yes, yes.
You already filed or you will file?
We will file.
The respondent return.
Respondent number 1.
Number 1. The respondent number 1, return candidate, has filed an application under Order 7 Rule 11 of the CPC, read with the relevant election, High Court election rules. Stop. Mr. Your name?
D. Singha.
D. Singha. Next paragraph, Mr. D. Singha, counsel for the petitioner, praise is allowed. How much time?
3 weeks time.
Praise for 3 weeks time to file reply. Praise allowed this up to 3 weeks, yes.
Lordship, only one aspect, since
Yes.
Lordship knows that in the 711, perhaps only the plaint is to be looked at.
Yes.
Maybe the requirement, the reply in that sense may not arise. Lordship may only consider that.
No.
Otherwise,
Let them see the thing. The once a 711 application has come, whatever it is, they are entitled to some sort of reply.
Lordship,
Like an election
I'll
petition,
leave
yes.
Item number 5.
Yes. Arnold, election petition,
My lord, affidavit in opposition has not yet filed, my lord.
Some more time.
When was this filed, Mr. Kumar?
My lord, March.
When was the
month of March.
Oh, March, okay. How much further time? Further 3 weeks time as prayed by the learned by Dr. N. Bozika on behalf of funds allowed for filing of affidavit.
6.
But 6 also I'm praying for some time.
Objections, Your Lordship. Your Lordship, if I may, the
Interim
order
order.
will
3 weeks or 2 weeks?
3 weeks.
3 weeks time is parades allowed for filing of affidavit to the counsel for the on behalf of the respondent. Stop. This is matter on so and so interim order. If any shall remain, shall continue till next day.
highly oblige, Your Lordship.
7.
When I see human. I had a temperature, you said 21 or 22. I know I know. Huh?
My lord, I'm praying for 3 weeks time to file my affidavit in this matter.
What's the matter about?
The Nokma, retirement.
Nokma?
Retirement benefits.
Gratuity?
Yes, my lord.
How is the council handling these matters?
We are bankrupt, my lord.
Whatever it is, but the thing is that is the right, there has to be some kind of
There is no dispute about it. There's no dispute.
you can't make these poor people come to court all the time for their, what is, if something that they feel vested rights different, whatever, perceived right, but then this is the,
Just 3 weeks, my lord, we'll file the affidavit. Positively.
further 3 week time as placed granted Mr. SD for affidavit on behalf of the respondents. Based on so and so.
Item number 8.
But here also I'm required to file affidavit.
Yes, but you've given enough time.
Last order.
In fact, it was sent for signature, my lord.
No, last one,
So 3 or 4 days
has
time.
given 4 days time, and thereafter my lord directed me, if required, I will file a rejoinder. My lord, they
No,
are
Mr.
by-
San, only disturbing things regarding that new, what you had submitted last time, you said you tried to bring some materials to show that.
No, I'll file my lord. Once they file an affidavit, that's what I last time made a
You
submission.
said
my
you'll
lord.
bring materials to show that, that has been made defunct and they've,
Yes,
to
I'll bring-
circumvent the order of the court, they've taken to another place.
Yes, Your Lordship. So they
We
had
need
that's
that on record.
My lord, but he has to file an affidavit, Your Lordships. That is
File
what my last
file it
affidavit
within
says.
2 days.
I'll place everything before Your Lord.
By Monday, you'll file. Today is Wednesday, my lord. Monday or Tuesday.
I don't know, my lord, why they are buying time here. They are trying to, my lord, illegal thing they have committing now. By asking time, they are not trying to normalize it.
That's not correct. What is being submitted is not correct, my lord.
Trying to normalize it. Why they are shy, feeling shy to file an affidavit?
It's not a question of shy, my lord.
Lordship has directed within 4 days.
Is you pay costs. By order date 22/5/2023, the respondents had prayed for 3 days' time to file an affidavit. Stop, the said affidavit is still on record. Stop, next para Dr. Mbozika.
It's April,
Legislative Council.
Filed in April, my lord.
Maybe, but there is a sense of urgency, Your Lordship is appreciated.
For the respondent submits it due to what circumstances you couldn't file it.
It has been sent, my lord, to the department.
Submits that the
I
affidavit.
could not follow it up, my lord, last week.
Therefore, will be filed positively by Monday, feeling which
then I'll pay
the court will be compelled to impose heavy cost. Yes, this is matter on Monday. Otherwise, you're circumventing the orders of the court.
But instead of Monday, can be Tuesday, my lord. Because Saturday, Sunday, again, non-working days, my lord.
Okay,
I'll
Tuesday.
file it by Monday, maybe afternoon or evening, my lord.
Okay, let's matter on Tuesday. You don't know whether you file Monday or Tuesday, but Tuesday.
My lord.
Item number 9.
Tuesday is what day? 20th?
20th.
Not 22nd. Yes.
May it please your lordship. Lordship, in this matter, so far as state is concerned, I am praying for 2 weeks' time, your lordship.
Where's the petitioner? Very good.
4 weeks.
Where's the wakalat? You already filed yesterday. I filed wakalat mahayana. Jo. Okay. Mr. Peter P. Doctorate standard appearance number 5. And prays for how much time?
Let it be 4 weeks, your lordship.
But it will be 3 weeks. We can't be so generous. And prays for 3 weeks time to file affidavit stop. Similar prays made by another EAG on behalf of the other respondents. This is the matter of prayers allowed just after 3 weeks for affidavit.
Apply, your lordship.
10.
Our lordship, so far the state is concerned, this matter also I have a similar prayer, your lordship.
On behalf of respondent number 4, not on instructions I am entering appearance. However, my lord, they are sending wakalat nama from Garowe. Philip. 150. Number private respondents. Okay. Mr. Kim Varasati, Learned Counsel, has entered appearance today on behalf of the respondent number 4. And as such, service on all the respondents is complete. Stop. How much time?
3 weeks, your lordship.
Next parameter. Indishwara and AAG. Prays for and prays that 3 weeks time be allowed to file affidavit. Stop. Similar prays made by Mr. K. Borachari, perhaps one before. Prays allowed. List the matter after 3 weeks.
Apply, your lordship.
11.
For affidavit.
The same matter, right? With the other matters, you will need affidavits here also, or can we take it up and on the basis of
The circumstances are the same, my lord. There are 2 sets of cases.
You
One
are pairing other cases similar?
Yes, yes.
How many cases are there? The similar ones?
The total
This
4
nectar?
cases. Including these, there are 4 cases. Some by
When are they
Mr. Paul,
listed?
some by Mr. Mahanta, one by Madam Badua also.
When are they? When is it listed? The next matter? We list them all together.
No idea.
You don't not aware.
I'll just check in from the court master.
Yes.
Just check those 3. But those are fixed on different dates, my lord, as of now. Those 3 matters are not listed together. So when those matters come, you can list it together.
But but will you need to file an affidavit here
I'll file an affidavit.
for the record?
But what is the same affidavit?
Yes. Dr. Muzika's letter DSGI, assisted by MSS Rumthao, counsel for the respondent, submits that though this matter is substantially similar to other 3 pending matters in the court, an affidavit is necessary to be filed. He further prays that since the other matters are similar, that they be listed together on the same day. The same not objected to by Mr.
B. Snaitha.
Yes, by B. Snaitha, counsel for the petitioner. Well, this is matter after 2 weeks.
On the same date, I'll provide the
Yes,
date.
this matter on so and so. You just give the date to the court
Yeah, I'll
master
give it now.
for further orders. Yes.
12.
It is a pensionary matters. My lord can fix this matter after 3 weeks. I heard, my lord, some of the amount has been released.
What about the last order?
Certain materials were to be brought.
Yes, act, my lord. But in the meantime, my lord, I came to know that some of the arrears amount has already been released. If that be the case, my lord, we'll withdraw this case. I just pray for 3 weeks time, my lord.
Lordship, I'm appearing on behalf of respondent number 3. Lordship, this morning I got hold of one letter dated 14 February 2023, which I think will help in the adjudication of this
It's
matter.
already been paid.
It's not been paid, Lordship. Then there's a letter saying that they are entitled to.
I think some of the amount has already been released, my lord.
You're serving as?
MLA, I was MLA, my lord, ex-MLA.
Lordship,
1 second. Actually, substantially, then your grievance does not.
Yes, in that case, my lord, I will withdraw the case also.
And Lordship,
I'll just confirm.
by this letter dated 19 May 2023, all the treasury officers of all the districts also
They've been
have been
instructed.
notified.
Yes.
Yes. But in that case, my lord, I will withdraw by the next date, my lord. I will just...
You withdraw 2 days was there.
My
Yes,
lord,
Sushila.
I need to
Lordship,
confirm,
as
my
per
lord.
instructions, Lordship, the nodal office has released the entire pension of the writ petitioner on 16th of May 2023, Lordship.
We'll not keep it pending. Because if this you've seen the letter of the principal accounting
Just
general.
recent.
Yes. 14th February.
That is
There's
the
no point
parallel
in
comments, my
burdening
lord.
the docket unnecessarily. Yes. This is as per the instructions received.
Yes, as per the instruction, my lord can dispose this case also. There is no...
Yes. When the matter is taken up today, MS Senior Come Advocate MS NG Shila has produced written instructions wherein it is categorically stated that the Accountant General ANE White letter number so and so Sakruddin, dated 14 February 2023, had prepared a statement for payment of pension and forwarded to the nodal office of Shillong South Treasury for payment by letter dated 16 May 2023. Stop. It is also indicated in the instructions that the nodal officer has since released the entire pension amount with petitioner on 16 May 2023. As per the records of the pension database, the amounts reflected will be credited to the account of the petitioner. The petitioner stop. Mr. Kikarmoplang has also produced the said communication being number so and so dated 14 February 2023, which justifies the instructions as received, and also the letter dated 19 May 2023, whereby all the treasury officers in all the districts have been notified with regard to reviewing all similar cases of ex-MLAs and MLAs. In this view, the matter, next paragraph, Madam N. Sinkon submits that as there nothing remains for active consideration, we may be allowed to withdraw the writ petition. Yes. Accordingly, matter stands closed and disposed of. I'll return these. I'll just keep it.
Much obliged, Lordship.
Hearing 14.
Oh, yes.
This is your Lordship. Your Lordship, in compliance with the order dated 23/5/23, Your Lordship, an affidavit has been filed, Your Lordship. If I take Your Lordship to Annex 8, page 5 of the additional affidavit.
This is page
page 5, Your Lordship, Annex A of the additional affidavit filed on 8/6/2023, Your Lordship. Lordship will kindly have a look at serial I, creation of post. One, Your Lordship. Creation of post, Your Lordship. If I may read from the beginning, Your Lordship.
Yes.
Lordship, this is the letter issued by the Government of Meghalaya Finance Economic Affairs Department on 19/1/2011. This is from the Additional Chief Secretary, Finance Department, to all Principal Secretaries, Commissioners, Secretaries to Government of Meghalaya, all Head of Department, Government of Meghalaya. Subject: economic measures in respect of administrative plan and non-plan expenditure during 2010-2011. I am directed to say that in the context of the budgetary deficit and the resource constraint being faced by the state government during the current financial year, it has become imperative to curtail expenditure and observe strict austerity in all areas of expenditure. With a view to achieving this object, it has been decided to adopt with immediate effect the following economic measures. Lordship, in this case, we are concerned with Your Lordship, creation of posts. No new posts under plan should be created without prior specific concurrence of Finance Department. Creation of new posts under non-plan will not be entertained. Delegation of power to Administrative Department and other authorities in this respect is suspended to that extent. Then, Lordship, I'll take to Lordship, I'll stay away to page 11, Annex B. That is the office memorandum, Your Lordship. This is also issued by the Government of Meghalaya Finance Economic Affairs Department, Your Lordship, 17 July 2011. It is like this, Your Lordship. Subject: economy measures and special economy measures in expenditure both under plan and non-plan during 2011-2000. The undersigned is directed to say that austerity economy measures and instruction contained in this department dated so 19/1, that means, Your Lordship, the one which I have read, will continue to remain in force during 2011-2012 and until further orders. It is reiterated that the instruction contained therein must be strictly followed. Subordinate officers under your respective administrative control should be instructed accordingly. So, Your Lordship, in view of this, Your Lordship, as stated in paragraph 6 of our affidavit, Your Lordship, that is why
this affidavit,
Lordship, the affidavit, the first
main affidavit,
the first affidavit, Your Lordship, the affidavit in opposition, Your Lordship, Lordship, kindly come to page 2 at paragraph 6.
Yes.
Lordship is with me. Lordship, kindly see the statement made that with regard to the amendment made in paragraph number 2.2 of the writ petition, the answering respondent state that with the appointment of various officials in different departments, the requirement of grade 4 staff to be attached to these offices, office of various functionaries also equally arise. It should be arise. I'm sorry, Your Lordship, this is a spelling mistake. The requirement of these grade 4 staff was initially above 91. However, since there was a restriction in creation of regular posts as such, in order to ensure smooth functioning of the offices, the department proposed the requirement to be met through casual or contractual appointment purely on a daily wage basis, and in portion to which an advertisement dated 20th-1/2012 was issued, by which the petitioner was appointed purely on temporary, casual, and daily wage basis at the rate fixed by the Labour Department. The rate, Your Lordship, has been fixed by the state government. At present, Your Lordship, they were paying 15,000, Your Lordship.
Only one thing, Mr. Shula, if I correctly
Lordship.
remember this matter,
Lordship.
The petitioners have said that you can't apply the RCW scheme to their employment. Is that correct, Mr. Jindal? That is the thing. That you can't offer them regular casual worker status.
Lordship, to that
that is one thing which needs some clarification.
Lordship, to that I would, in my humble and respectful submission, Your Lordship, then Lordship, I'll take back, Your Lordship, to the to the advertisement, Your Lordship. The advertisement, Your Lordship.
So whether by the terms of their employment will they can make them come within the scope of the eligibility to see their claims that look, a subsequent advertisement was advertised for the post against which they were serving. Okay, now you have all tried to show to the court that at that point of time there was embargo on
because of the ban, Your
posts,
Lordship.
yes, and
Lordship.
so to smooth functioning of the offices, you had resorted to
Lordship.
this casual appointment of grade 4 staff. Correct?
Lordship,
Fine.
yes.
Now they're saying that since new advertisement has been issued against a post, not against post they're serving, but similar to what they're serving, that they be accommodated against those posts. Number one.
Lordship.
And number two, that you instead of that, you've offered them regular casual worker status. Now, for the first point, if I correctly remember, I don't know, you can correct me if I'm wrong.
Lordship.
Is that that cannot be done? They should be considered against those posts that have been advertised. And number two is that if the offer of RCW is unacceptable for them because they do not come within that ambit and scope of that they can be put under regular casual worker status. If I remember correctly.
Lordship, my humble and respectful submission, so far the claim, Your Lordship, so far the claim of regularization, Your Lordship, in my humble and respectful submission, Your Lordship, they are bound by the terms and conditions, Your Lordship, laid down in the advertisement, Your
So
Lordship.
leave aside regularization, okay? Now come to
Lordship,
RCW status.
Lordship, petition, they knew fully well, Your Lordship, the condition of service.
No. Now come back to that. Where's that, Mr. Jindal, where they offered RCW status?
In their affidavit only they
What in this case? Anyway, I just remember.
Lordship,
in their
yes.
affidavit they have
Lordship, we have stated in paragraph 13 at page 4, Your Lordship.
4 and 5 both.
Yes.
Lordship, yes. So, Your Lordship, in view of the fact that the appointment which the petitioner have voluntarily accepted, Your Lordship, knowing fully the terms and condition, the service condition of the Lordship, that they are Lordship, the term of the appointment of the petitioner are casual in nature.
No, that's fine. That's fine.
Are casual in nature. That is why, Your Lordship, that is why, Your Lordship, the scheme of 1996 has been made applicable to the petitioner, Your Lordship, because the moment they continue for 10 years, Your Lordship, then by virtue of clause 3, if I'm not mistaken, Your Lordship, then they will, if any vacancy arises, then they will be considered, Your Lordship, to any group D post.
No, we're not there. So the thing is that now, okay, since recruitment, if any is to be made, is governed strictly by those secretarial rules, right? Now you have done the recruitment because of the embargo on recruitment, devolves the rules.
That is why, Your Lordship, that is why, if Your Lordship are recalling my submission, Your Lordship, that is why, Your Lordship, the petitioner, they have willingly accepted, Your Lordship,
No,
the advertisement.
we're going,
At this
we're going
moment,
in
Your
the
Lordship, they
process.
cannot turn around, Your Lordship.
We're not in the case of petitioner. It's just that this is the basic parameters, correct?
Lordship.
Now, the rules prescribe for certain mode of recruitment. Okay,
Lordship,
number one.
correct, Your Lordship. Yes.
Now, certain mode of recruitment have been prescribed, and because of the embargo, they have been recruited otherwise.
Lordship, yes.
Correct. Now again, they're still serving as a daily wage or casual worker.
Lordship, yes.
Whatever.
Then a minimum with
the
a minimum
advertisement
wage, Your
comes,
Lordship, of
yes, minimum
15,000.
wages. So you want to say that they are in a class of their own, absolutely, exclusively, that do not come under the, though they work in the same establishment, they are not to be considered at par with any employees only serving there.
Lordship, yes, because we have paid them the minimum wage, Your Lordship, of 15,000, Your Lordship. It is not a case of exploitation, Your Lordship. In my humble and respectful submission, Your Lordship, they were given a reasonable pay, Your Lordship, of 15,000 per month, Your Lordship.
What reply have you made to the last affidavit?
Then, Lordship, another aspect, Your Lordship, because the contention of the petitioner is that since there is a rule for making appointment, it should be made as per the rule, Your Lordship.
So that is the court has noted that is why this court is saying that although the mode of recruitment is already given there,
yes,
but then they were not recruited the mode that was illegal.
Lordship, my humble and respectful submission, Lordship, they cannot turn around, Your Lordship, and
What do you
see
mean,
otherwise.
turn around?
So
you mean
turn
that
around,
they should not have accepted,
means, Your Lordship, that
the term of appointment initially?
they should not contend now that the advertisement should be made as per the rule of 1997, Your Lordship. Then, Your Lordship,
just let me check if I have my old notes here.
contention of the writ petition is that they were recruitment was not made as per the as per the rules, Your Lordship.
Yes.
Then, Lordship, coming to the second advertisement of 9/2022, Your Lordship. This advertisement, Your Lordship, as we have stated in the affidavit, Your Lordship, in no way will affect the service status of the writ petitioner. They are free, Your Lordship, to take part in the selection process. That is my submission, Your Lordship.
This matter was last heard when?
Lordship, on 23/5, Your Lordship.
23/5?
Lordship, yes. That's all.
Today is
13, 14, Your Lordship, 14. 14.
Yes, President.
Lordship, how this additional affidavit came into it came into existence because of my averment made in paragraph 2.2 of my writ petition. Your Lordship will just come to paragraph 2.2 of my writ petition at page 9.
Yes.
There were initially 60 vacant sanction posts. Your Lordship, I am emphasizing the word vacant sanction posts of PN in SAD Nazar Department under the government of Meghalaya during the year 2012, and the department had obtained the approval of ARB department by their endorsement number 87 2010 14 2010 and finance concurrence on so and so date. So the concurrence of the finance and personal both departments were taken, and this is my specific statement that during the year 2012.
Where are these documents? Are they on record?
Pardon? No, these are not on record. These are not denied. That's what I want to
produce them. The thing is that now you see, now after it comes to the advertisement.
Yes, I'm coming, Your Lordship. Just give me 2 minutes.
Yes.
Then, Your Lordship, the selection process duly was followed as per the rules. There were advertisement and applications were invited. 2000 plus applicants were there. Those were scrutinized. Written tests were conducted.
Excuse me.
Interview were held, and select list after following the reservation policy was prepared. Police verification was also done, and after following the formalities, all formalities, this select list was prepared. Out of the select list, the first batch, there were 60 vacancies, 60 people were appointed, wide annexure 3, page 37. Now, thereafter, and these were against the vacant sanction post. Now, instead of giving the regular appointment, since they advertise for contract basis, they advertise on ad hoc basis, but gave the appointment on contractual basis for a period of 1 year. Subsequently, vacancies arose because of retirement, death, and promotion to the higher post. And those vacancies fell vacant, and those were sanctioned vacant posts. And on these posts also, candidates were appointed, Your Lordship. Now, they continued to serve more than 10 years, some of them, and thereafter they gave the representation that their services should be regularized. The matter remained pending with the state government for quite a number of years. Ultimately, they came up with one letter that your case will be considered for regularizations under the RCW. So far regularization matter, Your Lordship is concerned, there is no dispute. There is no dispute that government wanted to regularize. Dispute only lies on one fact, that is whether the regularization should be done according to RCW scheme or according to rules. Rules are in operations, and selection was done in.
But that is your biggest obstacle, Mr. General, is that your appointment dehors the rules.
No, that Your Lordship is not there.
Process might be the same.
Yes.
But your appointment against those posts dehors the rules.
Rules, Your Lordship.
For the rules. It's just
rules.
And you accepted that. I mean, you in a manner also,
Lordship.
There's been a waiver from your end also, in accepting this kind of appointment.
Lordship, I have, on last occasion also, I have pointed out that rules makes no difference between the casual appointment, ad hoc appointment, or regular appointment. Rule says that once you are appointed in accordance with the rules, then you become member of the service. And if you continue to serve for 5 years, you acquired a right of permanency.
Now again, you have to show how you became member of service. It cannot be taken because the mode of recruitment was on the basis of advertisement. That is the
Yes, Lordship. That mode of appointment was through the advertisement, and this advertisement, Your Lordship, was made. There is no dispute on this fact that these appointments were made on the basis of the advertisement, which were only for the post ad hoc appointment or ad hoc appointment, but these were against the vacant sanction post. Now, had they been appointed just like that, the rules, without following the selection process, then position would have been different. Here, Your Lordship, they have been appointed. Otherwise, there was no need to follow this due selection process. And from the RTI report, Your Lordship, I will show that there are 3 categories of peons. One is regular appointment, one is ad hoc or casual appointment appointed through the process of selection. And other third category is that those ad hoc or casual employees who are appointed without following the selection process. Both these categories cannot be placed on same footing. The one who is appointed under the rules, he acquires right under the rules. That is one thing, Your Lordship.
That is why that not of course not convinced that you come under the rules, not just telling anything else.
No,
because the manner of appointment,
there is nothing which is pointed out by my learned friend.
You don't have to point out. It's a question. You have to go on the materials that are before the court.
Lordship, what does the rule says? How the appointments are to be made?
They have not stuck to the rules. They have been advertisement. You have willingly, with the eyes wide open, gone.
Then Your Lordship, then it should have gone after 1 year. It should have gone after 1 year. It was only for a period of 1 year. On what basis they have allowed it to continue? They have allowed it to continue because these were deemed to be permanent. Same and except that in order to deprive these people from their legitimate salary, they have kept them in this manner.
What is the reply to the affidavit filed regarding embargo?
I am coming to the affidavit, Your Lordship. First, I will point out, Your Lordship, their additional affidavit, which they have. Your Lordship will first come to page number 3 of their affidavit.
The last affidavit.
Last affidavit.
Page number 3.
3.
Yes.
Hence, in view of above, the answering deponent most humbly also states that all the incumbents recruited by the advertisement of 2012 were on a non-sanctioned post created. Your Lordship, at least I fail to understand what is this English, Your Lordship. Non-sanctioned post created. How can a non-sanctioned post be created, Your Lordship? It's a just confusing and misleading statement by the department. Can there be a non-sanctioned post which can be created? That is their reply.
Yes.
Then Your Lordship will see paragraph 5. In paragraph 6 of the original affidavit, they have stated that there were restrictions. There were restriction on the appointment of regular post.
No, it's not a question of appointment. There are two questions. The question is creation of regular post and appointment.
No, creation, your lordship.
Now your case is that the order
Posts were already created.
Existing posts.
Yes.
Existing sanctioned posts.
Yes.
Okay.
Yes. Then your lordship will see paragraph 5 that the answering deponent reiterates that there was a restriction. They use the word here restrictions. That there was a restriction in creation of regular post which was circulated wide letter number so and so, Shillong, 19th January 2011 to all departments in the state, and again wide office memorandum number so and so, reminding all department in the state that due to extraordinary economic measures, the instruction contained in their letter dated 19/1/2011 be strictly followed. Hence, in view of the instruction and circular of the Finance Economic Affairs Department, Government of Meghalaya, the answering, your lordship, this is important, the answering deponent herein states that there was a strict bar for fresh recruitment. There is a difference between bar and restriction. Their submission is this, that there was a bar, and in the first line they say restrictions. And if I definitely I understand that learned AG will be double AG will be knowing better that there is a distinction between restriction and bar. Now they are misleading. In the first paragraph at page 3, I have pointed out non-sanctioned post created, and in the second paragraph they are telling, at one place they are telling there was a restriction, in the second place they are telling there was a bar.
Yes.
Bar. What do they want to say? They are not clear. Then your lordship will see, come to their annexure.
We do not have to go by the women's been affluent. We look at the letters which have annexed. What does it do? What do they convey?
Which one?
We look at this memorandum. That's all.
Yes, lordship will see annexure A, page 5.
Yes, let's go there.
Yes.
That'll be better.
Now, it's a letter dated 19th January 2011.
Yes.
Economy measure in respect of administrative plan and non-plan. Your lordship, this is a letter which is written by the Economic Department of the state of Meghalaya.
Yes.
For a particular year, and that certain economic measures are to be followed. Nothing but only certain economic measures for a particular financial year are to be followed. Now, one of the measure is this, that no post will be created without the no post under plan should be created without prior specific occurrence of the finance department. Creation of new post under non-plan will not be entertained, your lordship. Now this is only speaking about that without finance department approval, no new post under for this particular financial year, your lordship, financial year should be created. Now, your lordship, they say we followed this. Now, paragraph 7 of the same, item number 7 of the same says, paragraph 7, employment of casual labor should not exceed more than 3 months. State has not responded, controverted that if it was a restriction for 3 months, how could they appoint the person for more than 10 years? Yeah. There was a restriction by this economic letter itself that they are not to be appointed for more than 3 months. Then, your lordship, I have filed a reply to this affidavit, one thing more, Your Lordship, I'll point out in their initial affidavit, in paragraph 6, Your Lordship, as we have read it, that there was a restriction in creation of regular post. Here they say creation. In the second affidavit say there was a strict bar. Department proposed the requirement to be met through casual and contractual appointment. Then in Your Lordship come to paragraph 11
Of
the same affidavit.
first affidavit again,
First affidavit.
or the additional affidavit?
No, first affidavit.
We're jumping from here to there. Anyway, okay.
Just I'm trying to. I'm sorry, Your Lordship.
If it's like this, I need bullet points. Otherwise, I can't retain it. There's anything. If we go here and there, like every four.
I'm coming to the original, sir.
Yes.
11.
Para 11.
11.
Yes.
Page number 4. The answering respondent states that it is also a fact that with regard to resolve the pending regularization of services of the employees, the answering department decided to issue advertisement only for the vacant post without accounting the posts which has been already occupied. This decision was duly informed through the so and so. Hence, the post occupied by the petitioner were not put up for advertisement. Here also, Your Lordship, they are telling that they say post held by the petitioners. That means we are holding some post. We are not without the post. Had they terminated me after the contractual period, matter would have been ended. I was holding the post. Only the thing, they were not paying me. And for that, Your Lordship, my second prayer before this honorable court is this, that I am entitled for equal pay. Regularization, no regularizations. But I am entitled for the equal pay. Because my source of employment is same and my duties are same. I have annexed the copy of the rule that I perform the same duties and same responsibilities. And when that is a position, I have placed number of judgments. I am entitled for equal pay for equal work. Now coming to the additional affidavit, once again, Your Lordship, at page number 13
of your reply,
of my reply, type page is as 15. Your Lordship, this is one of the RTI information that vacant post in SAD Nazrat 194, and this is on 22/11/2019. Total number of employee, permanent employee SAD 580. Total number of employees who are casual employee 215. Total number of employees who are casual employee in SAD grade 4 who have passed their written examination conducted by the authority concerned in the previous year 131. Total number of employees who are casual employee who have not passed any written exam conducted by the previous year, this is 84. These 84 numbers can be covered under the RCW because they have come dehorse the rules. I have come through the written test and the interview and the reservation policy and complete, and that is what is the requirement under the rules.
It has all the trappings of regular selection.
Yes.
That is your case, yes. But the only thing is that it was,
and
appointment was casual.
Lottie will see next page, point number 11. point number 11, whether the casual implies working under grade 4 SCDN is a sanctioned post. Reply is all posts, regular or casual, are not without sanction. All posts are with sanction, Your Lordship. And the contention of this in the additional affidavit which is made, that there was that they are making very contradictory statement. At one place they say there is a restriction, other place say there is a bar. And another thing, the letter which they are relying, it creates it places only certain economic measures to be adopted. Then, Your Lordship, I'll take to page number 22 of my reply. This is a office memorandum dated 23rd May 2013. Paragraph 2. Further, all appointments made without observing the specified recruitment procedure of obtaining recommendation, either by MPSC, DSC or Department Selection Committee, are deemed to be irregular appointment. The appointment on
22.
Page 22 of my reply. So sorry, lecture 22, page 17. I am extremely sorry, Your Lordship. Page 17.
Yes.
This is a office memorandum banning of ad hoc temporary appointment in government department offices. I am reading paragraph 2. Further, all appointments, Lordship, 1 minute. Further, all appointments made without observing the specified recruitment procedure. What is recruitment procedure? Is prescribed. Of obtaining recommendation either by MPSC, DSC or Departmental Selection Committee are deemed to be irregular appointment. Mine is not irregular appointment because we followed the procedure. The appointment on ad hoc basis, temporary appointment, also create complication, and this has put the government into an awkward position, since recommendation of the names for recruitment to various posts are made by the MPSC or DSC as per the procedures and rules framed by government from time to time. The appointment is also made according to the state reservation policy. This is the case, Your Honor, which is falling in my case. Now, in 23rd May 2013, government, the office memorandum say that this puts the government in a very embarrassing position, Your Lordship. Now, they should avoid this position. If that be the so, it is therefore impressed upon all concerned to ensure that no appointment on ad hoc basis or temporary appointment be made. So, state government, Your Lordship, has not stated anything in the affidavit on the face of this type of office.
But the sad truth is that in spite of such directions, they're still being made.
They're still being made. No, that is why, Your Lordship, problems are being created. Problems are being created. Now, regular post, they keep on appointing ad hoc basis from the back door, and pay them minimum wages. This is a fraud, Your Lordship, which is committed.
Yes.
Lordship will see another annexure, Your Lordship, at page 20. At page 20. This is issued in the year 2022, 21st November 2022. Now, this, Your Lordship, is the order issued by the personal department as laid down in the department letter number so and so. So many letters they refer, whereby ad hoc appointments have been banned. Therefore, it is reiterated that the following action will be initiated if there still exist cases where appointing authority who had made temporary or ad hoc appointments.
So what do you understand by ad hoc employees, a procedure for ad hoc and without procedure?
Yes.
You already referred earlier on to the rules itself.
Yes.
That says that there are certain categories, one which are selected, one which are unselected.
Unselected.
For written examination.
Yes.
But the status, how will it differ? Now, the only difference is that you say that those people who have not come by a written exam, they will only be eligible for RCW.
They can be placed under RCW.
While as for you, RCW will not be applicable.
Because we are according to the rules.
Yes, okay.
And in our case, rules should be followed. And what does the rule says? I have already pointed out, Your Lordship. If just let me complete this paragraph 2 of this order. This order, any appointing authority who makes such appointment will be held responsible for violation of instruction. The government has the option of initiating proceeding against the officer and deducting the liability of ad hoc employments from the salary and pension. These are the instructions of the government here. And despite all these things, they are creating a havoc in the public employment.
But this 22 memorandum, they appointed that your ad hoc appointment in 2012.
Yes. No, Your Lordship, this ad hoc appointment, ad hoc appointment is also the rule of the day. Is also the rule of the day because of certain necessity to meet. But it should come to an end. You can't keep a person for more than the period for which and you allow him to continue for 10 years, 20 years and pay them 5,000 rupees.
We're doing the same thing in this High Court. We have so many contingent employees who are appointed out selection. So what can you say about that? So,
Lordship, this is happening. Your Lordship, a time has come when Your Lordship will to deal with normal cases is very only once in a while Your Lordship gets opportunity to deal such matters, Your Lordship, because it concerns the general public, and a signal should be sent to the government that we are here to look into this type of happening. I leave it up to Your Lordship to take such a call. And what I was pointing out, Your Lordship, I just wanted to draw Your Lordship attention to the rules once again. Your Lordship will see paragraph, page 21 of my rejoinder.
First rejoinder.
First rejoinder. First I filed a writ petition. Then
because out here the two affidavits, two rejoinders, correct?
Yes, yes.
Yes.
Here, Your Lordship, page 21, definition of service. Service means the Meghalaya Civil Secretariat record supplier so-and-so and other grade 4 staff service. Then composition of service. Constitution of service. The service shall consist of the following persons, namely I am concerned with E. Persons recruited to the service in accordance with the provision of these rules.
That is where the whole obstacle lies.
Yes, that is where, Your Lordship, I am telling that we are appointed.
That is the whole question.
Is there anything in this rule which my learned friend can show that if a person is appointed ad hoc basis without following the rules,
can be considered not to be in the service?
Yes. And whereas specifically what is the condition, what is the rules for appointment, it is prescribed here. And my learned friend has shown not even one clause that which was not followed.
I think Mr. Shulai will come with some authority with regard to this. This is a very peculiar situation. Is there an authority where rules are there prescribing a certain manner of recruitment and appointment beholds the rules and they're allowed to continue, whether they cannot be considered,
And these are, Your Lordship, not the ordinary rule, these are the statutory rules formulated under Article 309 of the Constitution. Had it be just a office memorandum, you see, it would not have, these have the force of law, whereas his office memorandum, etc., may not have the force of law, executive instruction. Though they also have some guidelines which are binding upon the state. But when there are rules, Your Lordship, and appointment is made in accordance with the rules, and these rules, Your Lordship, makes no distinction between ad hoc and...
But then we come again, excuse me, we come again to the same question. Is the advertisement and the manner...
Then, Your Lordship, because, see, that contract comes to an after, first of all, they have not produced the terms of the contract. What were the terms of the contract? Because in any case, appointment was not on contractual basis. The advertisement was not for contractual basis. It was on ad hoc basis. Now they have made a appointment on contractual basis. Where is that contract? And that contract was, even if some contract they are hiding, they are not coming with the truth, Your Lordship. How many vacancies were there? They are totally silent, Your Lordship. I'll just place one more, Your Lordship, RTI report, which I just now got it. Your Lordship will see page 26. Page 26 of my rejoinder.
Second or first rejoinder?
First rejoinder.
Yes.
Rule 22. Subject to the availability of permanent posts, every member of the service shall be confirmed in the post to which he is appointed if he has completed at least 5 years of service to the satisfaction of the appointing authority and is otherwise considered fit for confirmation, Your Lordship.
It's not applicable to your
Lordship will see then sub rule 3. A temporary or officiating member shall be liable to be discharged or removed to the next lower grade.
Sorry.
They have not. And after 5 years, Your Lordship, I acquires a right of confirmation.
Confirmation is totally different. When you appointed...
No, confirmation, Your Lordship, it confers a right of permanency.
Confirmation does not arise in your case at all. We're not even going there. Yes.
No, but rule says, Your Lordship.
This rule is not applicable, I mean, to your conditions of service.
I'm gone by these conditions, Your Lordship. I'm gone by this. One of the condition of service is this, that I have to be confirmed after 5 years. And that is why, Your Lordship, for equal work, I'm claiming after 5 years of service, Your Lordship. Because I acquired a right. Lordship, look at these people, Your Lordship, they have a family.
We're not looking, we don't care, they have family or they have 2-3 families. We are a come with a petition
but
it's court. We look at the merits of the case.
I'm asking my rights, Your Lordship.
Anything else?
There are judgments which I have already placed, and if oral arguments are concluded, I'll just give a synopsis of my written.
You just give a, because you've gone here and there, so we'll need some bullet points. Similarly, yes, parties free and allowed to submit bullet points on the next date. This is matter on
after 2 weeks, Your Lordship.
2 weeks?
1 week. Or 2 weeks.
As you already handicapped this court with the, like, I've forgotten everything. Okay, 2 weeks, yes.
And oral arguments concluded.
We don't need to write anything, it's fine.
Obla, Your Lordship. 15th same, Your Lordship. Next item, same.
Remember the obstacle you have, that's the only thing.
17.
Because I understand the fate of these people.
No, no.
They've already been
Apart
working
from that, your lordship will
Mr.
also
Jindal,
consider the
they've already
right of
been-
these people.
The fate of these people
Right
working
of these
against this
people
post,
and
suddenly one fine day
attitude-
advertisement comes out.
and the attitude adopted by the state respondent in filing contradictory affidavits and not coming to the truth by showing that how many vacancies are in existence.
Yes.
Only one RTI I wanted to show you that I forget. I'll attach with my written up.
17.
May it please your lordship. Lordship, this is that matter under public law remedy, my lord, for seeking compensation for malicious and wrongful prosecution.
Yes.
We've come under Article 226, my lord.
My lord, the senior counsel is in the other court, but he has instructed that the petitioner can start, my lord. He'll be joining.
I will not have half-baked hearings.
My lord, I have already informed my colleague.
Who is your senior colleague?
My lord, my senior, my lord, Mr. AAG, my lord, Mr. B. Bhattacharjee he's appearing on behalf of the state.
I'll not have, if he's not there, we'll not take it up.
My lord, my friend can start his argument, my lord.
If he started, we'll conclude it.
My lord, he probably is on his way. I've already informed through message that the matter has been taken up.
I can start, my lord.
My lord, he can start. He'll be joining, my lord. I've
We'll
already
take after some time, follow the matter first.
18.
Pass the time being. Huh? Yes.
May I please, your lordship?
Start.
Your lordship, in this matter, we just enter appearance, your lordship. I humbly pray 3 weeks' time, your lordship, to obtain instruction.
Just enter appearance.
Yes, because the petitioner.
Okay, with whom? Alone?
No, with my senior only.
MSN Raji submits that they have just been engaged in the matter. We pray that she be allowed
3 weeks' time, your
3 weeks'
lordship.
time to no objection.
No objection.
To prepare the same. What's happened to the contract? Has it started again?
Your lordship, I have no instructions on that.
As usual. Yes. This was 3 weeks.
19.
Yes, Mr. Dikhi.
This is a case for compensation for the land acquired by the government for the construction of the CHC and the sub-medical center. So in this connection, I would pray that the record of the case may please be called for.
Where is the other side? Yes.
So the prayer is that, my lord, if the record could be called for, this affidavit is not proper. It is not throwing light on the subject matter, my lord, properly.
Your Lordship, Mr. KP is appearing in this matter, but he's on legs, Your Lordship, in court number 3.
How much land, Mr. Siddiqui?
I'm claiming the land of only two kattha, my lord. And the document which they are showing is about the 10 bigha land. It is not my land which I am claiming. They are saying that they have inquired a gift was executed maybe by me. But my land is only 2 kattha and they are showing the document which is 10 bigha. And it is not by me alone, but some other people's signature is also there. So that is why, my lord, I am praying that the record may be called about this sub-center.
Why up? Did you donate the land?
They say that I have done. My lord, please come to page number 13 of their affidavit. State respondent's affidavit, page 13. This is a letter dated 12th January 94, my lord.
No, but in para 9, para 8 of the affidavit say that. You read para 8 of the affidavit, page 4.
Yes, it is in connection with para 8.
Yes.
They say that I have executed a deed of gift in their favor, my lord. That is their claim. And I say that I am claiming only for 2 kattha of land. And this deed of a gift shows 10 bigha of land. This is not my land alone, my lord. This has got nothing to do with it. That is why I'm saying, my lord, please come to page 13, letter dated 12th June 94 in this affidavit. That is paragraph 8. Which is letter dated 12th January 94.
No, your acquisition land document, that's all. Now,
Yes, sir. But see, my lord, on 12th January, they are enclosing a deed of 1999. How could they enclose a deed of 1999 in 94? They are saying that we are sending some documents of acquisition in 94, but they are giving the deed of 1999. So that is why I printed the record, maybe called for.
yes, only that thing, Mr. Varasaji, see, that is this the correct deed you have annexed? I think
it might be some typographical error, madam.
No, typographical in the letter. 94.
94 is the letter, 99 is the deed.
This letter is dated 12 January 1994. And the thing is that you annex a deed dated 99. Are you sure that this deed corresponds to this letter?
It cannot be, my lord, in 94. How
must be like different deed then?
There must be some mistake, madam.
There's a mistake. It's apparent on the face of the record itself.
I may be allowed to.
Let them bring the records, yes.
Yes, my lord, that is good.
You bring the records.
Instructions, if necessary, we'll bring
yes, Mr. A. Siddiqui at the outset has drawn the attention of the court, this court to page 13 of the affidavit filed by the state respondents, wherein on a letter dated 12 January 1994, a land document, namely a deed of gift dated 6 June 99 has been annexed. Stop. The council subjects that this is an anomaly and the deed of gift as annexed is not the correct document. Stop. Like paragraph Mr. Kibi Varasaji, Nana GA, Praise is allowed to obtain instructions and to produce the records if necessary in the next date. When? Yes, after 2 weeks.
I'll pray for
yes.
2 weeks. This matter after 2 weeks for further hearing.
Can I pray for 3 weeks?
2 weeks. When they're 3 weeks, it'll be 4 weeks. You're right. I mean, before you file affidavit, you should check, the materials that they give. Sometimes these people also, they just send anything.
Check.
Supplementary one, item number 1.
May it please your lordships. This is a case, my lord, where I am challenging a transfer order, your lordships. Briefly, the facts are this: the petitioner joined the school, my lord, Pine Mountain School, as a teacher, your lordships. Now, my lordship is aware Pine Mountain School is under the effective control of the government, your lordship, and affiliated to ICSE board. Now, all the appointment, transfer, all these things are, my lord, in the hand of the government. Though they have a managing committee only concerned with certain welfare measures decision they take, nothing else, your lordship. Now, my lord, this writ petitioner has joined the school, my lord, in the year 1992 as a teacher. Now, my lord, thereafter in the year, my lord, 2014-15, your lordship, she was elevated to the post of principal in the year 2014-15, your lordship. She was elevated to the position of principal on the recommendation of MPSC, because that was a selection post. Since then, my lord, she is continuing as a principal, your lordships. Now, my lord, she is due to retire on 31st of July, my lord. Barely a little over a month left, your lordships. So while she was, my lord, preparing for her, my lord, retirement, planning her retirement, pursuing her, my lord, pensionary, other things, settlement of pensionary and other benefits, to her shock and surprise, my lord, we received a letter, your lordship, at page 19, my lord, dated 9 June 2023, that was served on me on 12 June, my lord, 2023. I'll just read out, my lord, very important this. In the interest of public service, Srimati A.K. Dingdo, Principal Pine Mountain School, Shillong, is transferred and posted as special officer. Lordship will take note of special officer, my lord. Recently, your lordship has decided, my lord, what is ex-cadre post. This is nowhere in this cadre, my cadre.
Which matter ex-cadre post?
Lordship, that recently Lordship decided. I think we have that decision. So Lordship has quashed the notification. A regular incumbent of a particular cadre, he has been transferred out, my lord, as a special officer. That has been satisfied by your lordship. Special officer, Office of the Director of School Education Literacy, Meghalaya, Shillong, on her own scale of pay at level 16 with effect from the date of taking over charge until further words. No deadline otherwise. Now, second part of the order. On transfer of Srimati A.K. Dindo, Principal, Pine Mount School, Shillong, Srimati such and such, Vice Principal, Pine Mount School, Shillong, will temporarily hold current charge of the Office of the Principal, Pine Mount School, Shillong, until further orders. Now, Lordship will notice few things here, my lord. No, this is in public interest. This is not, my lord, that there is...
Where you met a woman is retiring in July?
Well, I have been. That is my whole case is that.
Specific a woman that's retiring in...
That I meant. 31 sir. Lordship will come to page 5, paragraph 4. Bottom.
Yes.
She is due to retire from service with effect from 31/7/22 on attaining the age of superannuations. Well, when I am pursuing, my lord, all those things with the AG and all, this has come and admittedly this is in public interest. Now, my lord, what public interest? Lordship, what is the situation in the school now? Situation right now in the school is, my lord, we are holding the half-yearly examinations. These will conclude on, my lord, next week, 21st.
No, whatever it is, if she's got just now only a month and a half, what is the purpose of transferring a person?
And now, Lordship,
just joining time also will be another already half the period for retirement.
While I was preparing this writ petition, another letter was served, dated 7 June, the next page, your lordships. Now there they say, this is not connected though, there they say that the director of my lord literacy, he made an inspection in the school on 31st May.
31st May. Ministry Department inquiry. I mean, even it can go on after retirement also. What is there?
No, my lord, that your lordship, that is not an inquiry. There they say you streamline, these are the things required to be streamlined. That day I was on casual leave. They were fully aware that I was in casual leave. He inspected, I was not present. So my lord, certain issues were raised and I was asked, this is not a shock cause. Streamline the thing and file a report. I am preparing, I am under obligation to file a report. That is something else, my lord. Now, these cannot be connected, my lord, with the transfer order. Transfer order is purely in public interest. Now, what public interest? That too I have been posted where, your lordship? An ex-cadre post. Is it permissible?
My lord, it is the same cadre, my lord. If my lord will have a look, my lord...
No, not going to same cadre. The only thing is that if a person will retire just over a month,
yes, that is
what is the point of, what public interest will be served? If we allowed her to serve how many years in this post?
Little over, my lord. Effective days 35 days.
No. How many years she served as principal?
My lord, more than 30 years, 31 years.
Principal?
30, not as a principal. I was in the same school as a teacher.
As principal since when?
My lord, it will be almost 9.
9 years allowed to serve. Then?
My lord, she has been transferred, my lord, within the same district, my lord. That is.
Forget about the same district. Yes. It's a totally different thing. Right. How would you do matters like this? What is the need also? Just let her retire peacefully and then she'll have to go. She can't stay. You're not extending her services, are you?
No, madam.
This is something very unique, my lord. I have never come across that. They had to do it at this stage.
So there's a similar case also recently before this court with regard to some officer in Karhil. Same thing happened. Right. Within one, how? I mean, yes. I mean, 1 month left. 1 month left to retire, and then posting.
This order was stayed in it.
And Lordship will see that the copy was sent to the PS concerned minister. There, I don't know. Some political intervention.
I should not go to that instruction also, my lord. I just received the file.
Let him update instruction, no problem. But this need to be stated.
Let it come up after 1 or 2 days. Yes, I'll take instruction.
Let Mr. S and counsel for the petitioner issue notice. Mr. M. Sankan is present on behalf of all the respondents.
My lord.
All the respondents, no further notice is called for. So, the petitioner here is agreed with an order dated 9 June 2023, whereby she is stated to be transferred and posted. We would this agree with where she has been transferred and posted as special officer in the office of the Director of School Education and Literacy, yes, Meghalaya Shillong. Stop. Next paragraph. Mr. S.N. Learned Counsel for the press submits that the petitioner has been serving in the present post as principal of Pine Mount School, Shillong since
2014.
Since 2014, and is due to retire on
31st July.
On 30, due to superannuate on 31/7/2023. He further submits that on the verge of retirement, and as the petitioner is preparing for the same, she has been served with the order, which has served an order for which no reasons have been ascribed, or can the same be said to be in the interest of public service. He therefore prays that in the interim that the impending order be stayed. Next paragraph, Mr. N. Sincon, appearing for the state respondents, submits that there is no illegality in the impending order, in as much as the petitioner is being transferred within the same district, and as such no inconvenience will be caused to her. So, next paragraph. Having heard the counsel of the parties prima facie at this stage, the only point of concern for this court is the fact that the petitioner has been allowed to serve in the said post for over 9 years, and at the very fag end of her career has been served with the impending transfer order. So, in this view of the matter, therefore, the learned you are GA.
Yes, madam.
The learned GA is directed to obtain instructions within 3 days. List this matter on Monday. Monday 19th. So next line. In the interim, status quo as to the moon petitioner shall be maintained. There's no point if
You should suspend this order. Suspend
no,
this
status quo. Let's suspend it. Because you see, it's in.
Second call 17.
Yes.
Lordship, as I mentioned earlier, this matter, my lord, pertains to wrongful and malicious prosecution, my lord, for a period of about 6 months.
You're seeking a
compensation, my lord, monetary compensation.
Does these things happen here or only in America? Tortious liability of of the respondents. Yes.
My lord, here the brief facts, my lord, goes like this. My lord, the petitioner herein, my lord, is a army personnel. He's a retired ex-serviceman. He joined the Assam Regiment on 1996, 24/6/1996, my lord. His service spanning almost about 16 years in the army, my lord. And during his service in the army, my lord, he had unblemished career. My lord, he had participated in major counter-terrorist operations also. My lord, and he's a married person and born with 3 children. All are female, my lord, and he retired in the year 2012. At present, my lord, he's drawing monthly pension also, my lord. And my lord, his daughters were studying in Jawai it was Adventist School Jawai, my lord. And for the purpose of, my lord, accompanying his daughters, my lord, after retirement, my lord, he started to drive a cab in the vicinity of Jawai area, my lord. Now, my lord, interestingly, my lord, he rented a house at Joya also. My lord, on 14/5/2018, there was an FIR filed by respondent number 5. My lord, on the basis of that FIR, my lord, a Joy PS case number 1055 of 2018 was registered, my lord, and my lord, besides the other accused, even the petitioner was arrested. My lord, his date of arrest is 13/5/2018.
He was arrested on
13/5/2018.
Okay.
Interestingly, in this case, my lord, even before carrying out any
Arrested,
my lord,
correction, NDPS case.
not NDPS, my lord, it is under UAPA, besides the regular sections of IPC, my lord. And he was, my lord, initially 10 days judicial custody was granted to the police, my lord. And thereafter, my lord, the NIA took over the case. Initially, the investigation was carried out.
What was the charge?
The charges were under 121, my lord, 121A, 120B, 384 IPC, read with section 10 and 13 of UAP Act. Now, my lord, initially the police carried on with the investigation. My lord, subsequently, as per the schemes of NIA Act, my lord, the NIA took over. And my lord, from time to time, they sought extension of my lord, extension of his custody, my lord, which was granted. And my lord, during the custodial period, my lord, he was subject to torture also.
How long was he in custody?
He was in custody for a period of about 6 months, my lord. Now, my lord, it's our case that, my lord, during the custodial period, my lord, he was subjected to torture, and also, my lord, he was beaten by bullets of the service revolver. My lord, after that, my lord, the NIA the respondent failed to file the charge sheet within the mandatory period. Then they filed an extension application under 43D of the UAP Act, my lord, which was granted, and the extension happened from the custody happened from 90 days to 180 days. My lord, that application your lordship will find at Annexure 3, page 25 to 26.
Yes.
Your lordship will kindly see. I'll take your lordship to first to the credentials of the petitioner, my lord.
No need. I mean, you already said he's been a...
Yes, your lordship. I'll take your lordship to the application which the NIA filed. That your lordship will find at page 25, Annexure 3. Type copy your lordship will find at page 26. And this was interestingly filed in the after 3 months of his arrest. It says, my lord, I'll just read the operative part, my lord, that your honor was pleased to extend the judicial custody of the 4 arrested till 24/8/2018, that the judicial custody of 90 days in respect of the said 4 arrested accused is going to expire on so-and-so date, that several aspects of the investigation are yet to be attended to for collection of crucial evidence against the arrested person and other absconding accused, that the public prosecutor NIA has filed its report regarding the ongoing progress of investigation and cited specific reasons for further extension of time for completion of investigation and detention of accused person from 90 days up to 180 days. My lord, that application was allowed, my lord, and the extension was granted till 180 days. Now, ultimately, my lord, in the meantime, we also filed a bail application, my lord, which was rejected. And my lord, in the meantime, the charge sheet was filed on 15/11/2018, almost after six months.
What is his name?
His name is
Tudulang.
Thangao Pao Kamai.
No, Thangwan Pao
Kamai, sir.
Yes.
My lord, the charge sheet was filed on 15/11/2018.
Where is that?
Interestingly, my lord, in the said charge sheet, even though the charge sheet was filed and there was no evidence as against this particular petitioner, my lord, they did not sought his discharge, my lord. It was due to court's intervention, my lord, the petitioner before your lordship was discharged finally from all the liabilities of the case, because on perusal of the charge sheet, my lord, there was no evidence whatsoever.
See, but his name shown as Tudulang Kamai in this page 29. He's the same person.
No, my lord. Tudulang Kamai is another accused.
Then where does his name appear? That where does the order of the court? You said nothing against him.
Yeah, your lordship will find it at page 28.
Okay.
The order is 15/11/2018. This was the date on which the charge sheet was filed. And
Okay,
the court,
now para 4.
yes, Your Lordship.
Yes.
Yeah, I'll just read from the beginning, my lord. CR put up today, accused
No,
so-and-so,
yes.
so-and-so, so-and-so are produced before this court. CIO so-and-so, DSP and I present before this court. Charge sheet has been filed against the accused 1, A1, A2, A4, A5 and also against Shrimati so-and-so. However, the accused Shri Thang Thaulo Gonmai was never arrested during the course of investigation. That as per the charge sheet, no evidence was found against the accused Thangwangpao Kamai, alias Benjamin. This court is not inclined to further remand the accused Thangwangpao Kamai at Benjamin. The accused so-and-so is discharged. Now, Your Lordship, even though the charge sheet spelled nothing against this petitioner, my lord, it was after court's intervention. They did not file any discharge application. Rather, it was because of the court's intervention, my lord, he was discharged from all liabilities. Now, thereafter, Your Lordship, he was set free, my lord. After he was set free, my lord, he has been. It is my case, my lord. He's good, even though, my lord, it is a settled law, my lord. The baddest of bad person is entitled to be treated as per law, my lord. In this particular case, my lord, neither any 41A notices were ever issued to me. I was straight away arrested, my lord, and kept into custody for good period of 6 months.
You under UAPA?
I'm not under UAPA, my lord. I was, my lord. The case which has been projected by the respondents is that, my lord, I was found to be along with the accused person. Now here, my lord, I pose a question to myself, my lord. Here, the other accused were apparently arrested from a rented house in the vicinity of Jowai, my lord. Now, my lord, here it is an admitted position, my lord, that I am running a cab business. My lord, in the course of my business, some people, they hired my vehicles. I plied them wherever they wanted me to take. I plied them on rent. Now, my lord, if certain suspicious person, my lord, takes the vehicle on hire, and if they are alleged to be involved in certain crime, my lord, or an offence, my lord, it is highly probable, my lord, they will not reveal or they will not do anything which will give a slight inclination to me that, my lord, they are involved in any sort of a case. They will always do such things in a discreet manner. So I would not know, my lord, in any case, and it's not their case, my lord, that I was aware of everything, yet I participated in the event. My lord, it was a pure case of suspicion.
No, the bill discharge does that end there. I mean, the only thing is that you're claiming for compensation.
Yes. There was no evidence, my lord. And moreover, my lord, the respondent number 1 to 4, my lord, 1 to 4 says, my lord, that I was arrested on the basis of suspicion, my lord, because I was found to be at a wrong place at the wrong time. Now, my lord, your lordship is aware that suspicions, however grave, cannot take the place of a proof. My lord, in one point, they are saying that there was evidence initially. If that be the case, my lord, how can it vanish over a period of time? And the very stance which was taken by the respondent is negated by the affidavit filed by the respondent NI. Now, NI says the other thing, my lord. The NI says that he was arrested on a mistaken identity because he was mistaken to be somebody else who was suspected to be involved in the commission of crime, my lord.
Yes.
Now, your lordship, besides this, my lord, here, my lord, it is my case, my lord, ever since I was arrested, my lord, the public attitude towards me has changed drastically, my lord. And my lord, and I've been started to, my lord, looked down upon with disdain. And not even that, my lord, I have been living a life of humiliation ever since I was arrested. My lord, I am the entire illustrious career that I had in the army, my lord, it was just smothered in a jiffy by the respondent's act of impulsive act of the respondent, my lord. Here they arrested. My lord, if I may humbly submit that the power of arrest, the power of arrest comes with more responsibility. In this case, my lord, the power of arrest was used without circumspection, my lord. And my lord, The time that I spend in forced custody, it cannot be improved any further at this point of time. The only thing that I can seek before your lordship under 226 is some reasonable compensation, my lord. Because my good 6 months has been, my lord.
What about those people who have been wrongly imprisoned for years?
That, my lord, they have their own case. They have their own case. And it's not a case, my lord, that I have been discharged after trial.
See, one thing is that, what was the question? Sufficient evidence or insufficiency of evidence?
There's no evidence. Well, there's no evidence at all. It's not a case of insufficient evidence. There is no case. It's a case of no evidence.
Now you base your relief on what? Public law remedy.
Public law remedy.
That you should be given adequate compensation.
Absolutely. And my lord,
do you have any authorities?
I do have, my lord. This the latest is Mr. S. Nami Narayan, the ISRO scientist case, my lord, where he was imprisoned for 50 days on a charge of, my lord, espionage, space espionage case, my lord.
For him, it was really, he was robbed of his, a total, what do you call it?
He is also no less than a scientist, my lord. He is a serviceman who has spent about 16 months defending the country. And he has operated, he has participated in major terrorist counter operations.
Let's see the judgment.
This is your lordship, 2018, volume 10, SCC, my lord, 804.
See, that's why this court said this, asked a question, insufficiency of evidence or no evidence?
It's a case of no evidence, my lord. The order itself will say that. And it was not a benefit of doubt given to me, my lord.
But was he in the company of these other arrested
Yes,
persons?
my lord, if I am applying a taxi, my lord, if somebody...
See, the thing is that they whatever the invasive authorities are entitled to detain you.
Yeah, absolutely.
You have to secure your presence in the court's investigation.
Yes.
So that
My
is,
lord,
that,
I
that, that
can
is,
understand.
that is a
Had the
requirement
detention
which they'll have to. You cannot just let a person go. Suppose he was involved with the NACN, as is alleged, that you're supplying arms and all. How will you know? At the point of time we are together.
Absolutely, my lord. That is what I say, my lord. Had it been a case of 16 days or maximum to the period of 30 days, I would have not mind. My lord, for a premier institutions like NIA and the state police, my lord, does it take 6 months to find out that he's not at all involved in the case?
Yes, which part of the judgment to show?
My lord, here again, my lord, the question might arise that who's to be saddled with the liability if your
no
lordship...
question of saddling liability. It is in the course of normal investigation.
Yes. My lord, here I'm referring to page 40
You mean, Mr. Thapa, your objective in the writ petition is not for compensation.
I am for compensation.
No, it's not for compensation. Is it? You want to come in for vindication?
Not exactly, my lord. Then, like, that is why I say, my lord, if had the detention be only for a period of 30 days.
That is the vindication.
Not exactly, my lord. Had it been a case of 30 days custody, my lord, I would have not mind. Here, my good year, 6 months period in my life has been smothered in a very callous manner, my lord. Paragraph 40, my lord. Paragraph 40.
Long judgment of 40.
It's a very long judgment.
No, not that long. Yes, okay. Yes.
It is if the obtaining factual matrix is adjust on the above principle and parameters, there is no scintilla of doubt that the appellant, a successful scientist having national reputation, has been compelled to undergo an immense humiliation. The lackadaisical attitude of the state police to arrest anyone and put him in police custody has made the appellant to suffer the ignominy. The dignity of a person gets shocked when psychopathological treatment is meted out to him. A human being cries for justice when he feels that the insensible act has crucified his self-respect. That warrants grant of compensation under the public law remedy. We are absolutely conscious that a civil suit has been filed for grant of compensation. That will not bar the constitutional court to grant the compensation, taking recourse to public law. The court cannot lose sight to the wrongful imprisonment, malicious prosecution, the humiliation, and this defamation faced by the appellant. My lord, in Subeh Singh versus State of Haryana, the three-judge bench, after referring to the earlier decision, has opined, it is thus now well settled that the award of compensation against the state is an appropriate and effective remedy for redress of an established infringement of a fundamental right under Article 21 by a public servant. The quantum of compensation will, however, depend upon the facts and circumstances of each case. Award of such compensation by way of public law remedy will not come in the way of the aggrieved person claiming additional compensation in civil court in the enforcement of the private law remedy in tort, nor come in the way of the public criminal court ordering compensation under 357 of the Code of Criminal Procedure. In Hardeep Singh versus State of MP, the court was dealing with the issue of delayed trial and the humiliation faced by the appellant jury. A division bench of the High Court in intra-court appeal had granted compensation of rupees so-and-so. This court, while dealing with the quantum of compensation, highlighted the suffering and humiliation caused to the appellant and enhanced the compensation. In the instant case, keeping in view the report of CBI and the judgment rendered by this court in so-and-so, suitable compensation has to be awarded without any trace of doubt to compensate the suffering, anxiety, and the treatment by which the quintessence of life and liberty under Article 21 of the Constitution withers away. We think it appropriate to direct the state of Kerala to pay a sum of rupees 50 lakhs towards compensation to the appellant, and accordingly it is so directed. The amount shall be paid within so-and-so. We hasten to clarify that the appellant, if so advised, may proceed with the civil suit wherein he has claimed more compensation. We have not expressed any opinion on the merit of the suit.
Yes.
Now your lordship will kindly appreciate, my lord, after his arrest, my lord, he had to take all his bag and baggages from here, go back to his hometown, my lord. He in fact, he took his daughters away from here and he left to his hometown because the situation had become as such that the owners were not even trying to keep them in the rented house any further, my lord. And it was all because of a very callous action taken on the part of the respondent.
That's a suspicion. Anyway, yes, Mr. That's it.
Only thing, my learned senior here, I think would be referring to section 319, saying that, my lord, the investigation is still on, and if some evidence is, because that is what the affidavit says, that in case if there is evidence is found, he might be again called as an accused person under 319. Now, so far as 319 is concerned, my lord, it does not apply to a person who has already been an accused and has been discharged. It is only for a person. I have a judgment to that effect, my lord.
No, this is new to me. Yes, you show, because I am not, this court is not a.
Yeah, I'm relying.
Currently,
I will take in defense of 319. Let him place. I'll also place.
This is, my lord, 1990 volume 4.
1990?
Volume 4, SCC 580, my lord.
581.
580 page. Okay. The paragraph would be, your lordship, paragraph 43. Para 43, lordship. It is. Lordship, may kindly bear with me for a second.
No problem. Para 43 is not here in this. Sohan Lal.
Yes, Lord. Sorry, para 33. Para 33.
Para 33.
If I may kindly read, your lordship. Page 594.
Yes.
Yes, page 594, paragraph 33, lordship. The view, if you also has got it.
Yes.
The above views have to be yield to what is laid down by this court in the decision above referred to. The provisions of section 319 had to be read in consonance with the provision of section 398 of the court. Once a person is found to have been the accused in the case, he goes out of the reach of section 319. And this is my case, Your Lordship. Whether he can be dealt with under any other provision of the court is a different question. In the case of the accused who had been discharged under the relevant provision of the court, the nature of finality to such order and the resultant protection of the person discharged subject to revision under 398 of the court may not be lost sight of. This should be so because the complainant's desire for vengeance has to be tampered with, though it may be, as Sir James Stephen says, the criminal law stands to the passion of revenge in much the same relation as marriage to the sexual appetite. The APP's application under section 216, insofar as appellant number 1 to consent could be dealt with under section 216, appellant 4 and 5 could be dealt with neither under section 206 nor under section 319. In that view of the matter, the impugn order of the magistrate as well as of the High Court, insofar as appellant number 4 and 5, namely Vijay Bai and Jija Bai, are concerned, have to be set aside, which I hereby do. The appeals are allowed to that extent. Now, this Lordship clearly says that even in this case, the appellant number 4 and 5 were discharged, and subsequently, they filed an application under 319. Now, this particular
the judgment says that until you can't proceed any further, but recourse can be taken to other provisions. If
yes, it is to the revision, not to 319.
What's happened to this trial right now? Is still underway?
It is undergoing,
Okay.
But I have, so far as I have been absolved of all the liabilities in this case. And
right.
Your Lordship will kindly see the affidavit filed by NIA, the respondent number 5. Number 6. I'll take Your Lordship to para 13.
The respondent number
6, Your Lordship.
6. Para number
13.
13
and 14, my lord.
Yes.
During the course of investigation of the incident case, it has been revealed that accused petitioner so-and-so owns a car Renault Kwid having registration number so-and-so, which was hired by the main conspirator in the incident case, namely so-and-so, 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 before commission of crime, during and even after the commission of crime. The details of the vehicle purchased by so-and-so was also verified from the RTO. The petitioner so-and-so was arrested. Your Lordship, the other thing that Your Lordship will kindly note, it's not a case, my lord, I have been using a forged vehicle, my lord, to further the intentions of the accused persons or to the alleged activities of the accused person, my lord. Here, my lord, the vehicles were in my name, and there is no denial, my lord. I was running a car on a bona fide, my lord, belief. But the accused person so-and-so was arrested along with the other accused person even after extradition of so-and-so from the BPIL company in turn of releasing the abducted and police so-and-so. The main conspirator went by the above car driven by so-and-so. She belonged to so-and-so, wife of so-and-so, who was carrying so-and-so rupees out of the extorted money. Therefore, it was a prime responsibility of MI to unearth the entire conspiracy and to ascertain the involvement of the Benjamin in the incident case. The CDR and CDR analysis report of the mobile numbers of so-and-so, and it has established that so-and-so was in regular contact with the main accused number 1. Now, during the investigation, it was revealed that the accused person, Benjamin, disclosed that he is a army retired personnel of Assam Regiment and relative of Khamjang Rongbhai, and after retirement, he purchased the above mentioned vehicle and started flying his vehicle on hire. Now, I was more harping on, my lord, para 11, because it will show that, my lord, here the arrest was not on the basis of suspicion, not only on the basis of suspicion, but it was on the basis of mistaken identity also, my lord. It was a complete hotspot on the part of the investigating agency. Page 5, para 11. During investigation of the case, my lord, it was revealed that one person, namely Benjamin, is involved in supplying of arms and ammunition to the militant group, including NSCNK, a banned terrorist organization. He is based in Tamenglong and None district of Manipur, and also visits different part of Manipur, Meghalaya and Assam frequently. To ascertain the involvement of Benjamin in the unlawful activities, a letter number so-and-so was sent to Manipur police for providing the actual names and particulars, including photograph details of case registered against him, Manipur, and any other information in respect of the said Benjamin, an armed supplier of NSA and other militant group. The reply was received on so-and-so date, only through which it was confirmed that the person named Benjamin, who was arrested by the Meghalaya police on so-and-so in the instant case, is not the person whose name is also Benjamin and an armed supplier to the NSA. So it's a case of mistaken identity, my lord. At least they should have been a little careful while
No, it's not really a case because, see, in this
The name
case of
was
ISRO scientist case, see what happened was that he was singly arrested. No other accused were arrested. You know, that is the case, that espionage case. Like no other co-accused were there. No other arrests were made. He was arrested alone. He was, actually humiliated.
That is why, my lord.
That's different. That's on different footing. I mean, in this case, your case is that might be wrong identity, but he was in the company of these people who had extorted money from some industry, and his car also had been used to
That is
transport
why
a
I
portion
say, my lord.
of the
That
money.
is why I say it's not the case of the respondent that I was aware of everything.
Right, okay,
I
yes.
was aware of everything, yet I participated in the commission of crime.
Anything else?
Everything I did was, my lord, on a bona fide
business
Yes, my
transaction.
lord. In the course of, but that is why, my lord, I pose a question to myself. If I am to be made an accused in this case, or I am to be arrested, why not the house owner? Even a house owner could have been alleged of an offence of harboring the NSCN cadres, my lord. That was never done. Only because I might share the same dialect with the other accused.
The only
person.
thing is you're part of the same tribe.
Perhaps, my lord. But that cannot be the ground on which an arrest can be made so randomly, my lord. At least some kind of my lord.
Arrest was made on what principle?
Caution should have been
What
taken.
does arrest mean? What principle? It's the old adage: birds of a feather flock together. So that's
True, my
the
lord.
only thing.
And the other aspect, my lord, that is why I say, my lord, for a premier investigation agency to take, my lord, to quell that suspicion, my lord, it took 6 months for them to understand that there was no evidence against me. I am innocent. And by the time they realized that I am innocent, my lord, my 6 good months have.
So
already
any
been-
evidence of your physical torture being meted out to you?
My lord,
Have you made averments that so and so person?
I have made an averment,
possible
my
that
lord.
you,
I have
you
made
were
an averment
on
to
so and
that
so
effect.
date you were assaulted and were you put in an interrogation?
Now, I have made an averment, but I did not reveal it to the magistrate concerned for fear of
Why?
repercussions. For fear of repercussion, because I was threatened.
That is the first question. I should ask you whether you're in good health or whether
That
you're
is why, my
any
lord,
under
your
distress.
lordship is aware, my lord. A person who is in custody will never, at times will never speak the truth.
Even for the magistrate report is here. I mean, because even by seeing the demeanor, yes.
My lord, and the denial is very lame on the part of respondent number 5.
Respondent number 5 is whom?
He's the, my lord, the IO concerned.
Mr. Parse, you appear for IO.
We are for the state. IO is by name, my lord. So there is IO has been implemented by name. So my lord, Mr. Abraham is there, my lord.
It's been completed by name, so I'm representing him.
Yes. Anything else?
So, my lord, in my humble and respectful submission, I humbly pray, my lord, since in the case of ISRO, my lord, for 50 days they granted about 50
No, but see, he was a person who was arrested alone, not in connection with any other.
I understand, my lord.
See, the ISRO case totally different footing.
That is why I say, my
it's
lord,
just suppose you pick up some professor from some university, correct, who's very eminent.
That is why I say, my lord,
It's not immediately tarnished. He's been like
even to
his total
understand,
character has been assassinated.
my lord, for the investigation agency to understand,
And no
my lord,
matter,
that
no amount of
it
money
took
can
6 months for
compensate.
them. It took 6 months for them to even understand that I am innocent. And moreover, my lord, it was not on the application, my lord, filed by them that I was discharged. It was on after the intervention of the court, which did not allow them further remand, my lord, I was discharged. So their action speaks for themselves, my lord.
Yes.
Obliged.
Who'll start first? 15 minutes, we can finish.
My lord, this will not take much. It's only a question of law. So
I'm
far
sorry,
as the
my lord, before my learned senior starts, my lord, there are 2 judgments of the Honorable Apex Court on the issue of my lord suspicions, however grave, cannot find a place of
that is
proof.
not a case of conviction. There is no question. Those propositions of law
Here
will
in
not
this
come.
case, the primary argument is, my lord, I was picked up on the basis of suspicion.
That is okay. Is it you have not been charge sheeted.
Not been charge sheeted, but I was picked up on the basis of suspicion.
Anyway, those principles may not be that much relevant.
I have already submitted a list of books. I have already submitted a list of books on that issue also.
Yes, Mr. President.
Wait, please, Lordship.
Yes.
Now, my lord, here, my lord, so far as this factual aspect is concerned, my lord, the fact that the accused was arrested initially by the state police, my lord, and subsequently, my lord, the investigation was taken over by the NIA, my lord. And this matter was investigated by them. A charge sheet was filed. And now, my lord, the discharge of the accused here is on the basis
lack of evidence
of the, my lord, whatever was stated in the charge sheet, my lord. Now, Lordship may kindly come to that relevant part. My lord, since, my lord, the entire documents of this investigation have been annexed by NIA in their affidavit, I'll just, my lord, take your Lordship to their affidavit, to two relevant pages. Lordship may kindly come to page 147. That is the relevant page of the charge sheet, my lord. My lord, paragraph 17.30 down below. It speaks with regard to the petition, my lord. Now,
yes.
It says, during the course of investigation, one person, namely Thuangwang Po Kami alias Benjamin, aged 40 years, son of Sri So-and-so, resident of such as such police station So-and-so, district Kachar, Assam, was arrested by Meghalaya police on 14/5/2018, along with the other two accused persons, namely So-and-so A1 and So-and-so A2, due to his alleged complicity in connection with the incident case, and the said accused was lodged in district jail Joy, West Jointe Hills, after taking over the records from Meghalaya police. The present CIO prayed before the Honorable Special NIA Court, Shillong, for police custody to NIA in respect of said accused person for custodial interrogation. The court was pleased, and thereafter the said accused was remanded to NIA custody from 11/9/2018 to 17/9/2018. The said accused is presently under judicial custody and is lodged in district jail Shillong. During investigation conducted so far, it is found from the record in the form of oral, documentary, and technical evidence that evidence are not sufficient to prosecute the accused. Lordship will kindly take note of this page. So-and-so. However, this becomes this thing. Liberty may be kept reserved to prosecute the said accused whenever prosecutable evidence are found in further course of investigation in respect of the said accused persons.
Yes.
Now, my lord, that stipulation was there. Now, that is the charge sheet, my lord, on the basis of which he was discharged. Now, my lord, friend has relied on a decision of 1999 with regard to the discharge, my lord.
99, no?
1990, sorry. 1990, my lord. Now, this speaks about a discharge which it is made under section 245 CRPC, my lord, which is not at all applicable here because court had not taken any evidence at that point of time. Now, my lord.
Yes.
Now, what remains, my lord, is that my lord, if Lordship, my lord, takes into consideration the provision of section 319 CRPC, my lord.
Yes.
Lordship will find that where is he? That the court has the power to proceed against a person who is found guilty of offence, my lord. If I can take a Lordship, my lord, page 313, where in the course of inquiry into or trial of offence or trial of an offence, it appears from the evidence that the person not being the accused has committed any offence for which such person could be tried together with the accused, the court may proceed against such person for the offence which he appears to have committed. Whether such person is not attending the court, he may be arrested or summoned, or the circumstances of the case may be required for the purpose of this. So, my lord, that, my lord, option remains open. If, my lord, in the say during the course of trial, my lord, if any incriminating evidence is disclosed against him, even my lord, if it comes from the statement of any other witness, my lord, the court can definitely, my lord, summon that person and try him to be accused, my lord. Now, my lord, to buttress my argument, my lord, on that issue, my lord, I would just rely on the decision of the Apex Courts. My lord, it is 2021 SCC online, SC 217. Lordship, I'll take your lordship to paragraph 27. Sorry, my lord, there is no page marking, so I have to.
That's why. Yes. Right.
Paragraph 27. While answering question 5, namely, in what situation can the power under section 319 CRPC can be exercised, named in the FIR but not charge sheeted or has been discharged, this court has observed and held as under. However, where there is a great difference with regard to a person who has been discharged. Who has been discharged.
Given the citation to him, you are aware of judgment?
No, I have taken it down. I've noted it down.
Yes.
A person who has been discharged stands on a different footing than a person who has never subjected to investigation or is subject to but not charge sheeted. Such a person has stood the stage of inquiry before the court, and upon judicial examination of the materials collected during investigation, the court had come to the conclusion that there is not even prima facie case to proceed against such person. Generally, the stage of evidence in trial is merely proving the material collected during investigation. Therefore, there is not much change as regards the material existing against the person so discharged. Therefore, there must exist compelling circumstances to exercise such power. The court should keep in mind compelling circumstances to exercise such power. The court should keep in mind that the witnesses, when giving evidence against the person so discharged, is not doing so merely so to seek revenge or is naming him at the behest of someone or for such other extraneous consideration. The court has to be circumspect in treating such evidence and try to separate the chaff from the grain. If after such careful examination of the evidence, the court is of the opinion that there does exist evidence to proceed against the person so discharged, it may take steps, but only in accordance with section 319 CRPC without resorting to the provision of section 319 directly. Now, my lord, this, my lord, says that the discharge cannot be absolute, my lord.
Yes.
If even during the course of trial, my lord, if any evidence comes,
yes,
it can be discharged. So definitely, my lord, taking into consideration those provisions of law, my lord, accused cannot come up with this case at this point, my lord, claiming compensation.
Because the court's asking whether the trial is still continuing or
my lord,
whether
it's continuing, my lord. The trial is continuing. It's a evidence stage, my lord.
Lordship's knowledge, my lord, it's on the verge of completion, brother. And nothing
let him wait for the outcome, my lord.
Wait for the outcome.
Well, let him wait for the outcome, my lord.
So far as
if
come
at
out
all,
as
my lord,
against
this is only one of the aspects. Now he has relied on the principle of the Namiranayan case, my lord. Namiranayan case will not apply here, my lord. It's a totally different, my lord. My learned friend has not placed the facts here. I'll take your lordship to those things, my lord. Now, my lord, my lord, we are not disputing the fact that he was arrested. And then, my lord, subsequently, in the charge sheet, my lord, he was not named accused at that point of the time when charge sheet was filed. An investigation was done. My lord, I am appearing for the state. My action was limited to the arrest and initial detention of the accused, my lord. Subsequent, after the matter was taken over by the NIA, my lord, I cannot be held responsible for whatever has happened, my lord. If there is any extension of detention, all this will be for the NIA. But then, my lord, the affidavit filed by the NIA is in detail, and it says, my lord, that yes, there was prima facie ground for detention because this person was, my lord, found ferrying those discharged accused, my lord, and he was, my lord, not in only one occasion, my lord. It's more than on one occasion. Yes, my learned friend has said that he was having a business of ferrying passengers by a taxi,
Yes.
my lord. Now there is nothing on evidence to show this is a commercial taxi, my lord.
There's no registration. Is it
nothing? The record is
affidavit filed by NIA bears it out, but they have gone to the extent of verifying it with the DTO, and it is found to be in my name.
That is
No,
okay.
I mean,
but I'm
is
not
it
saying it's a
taxi?
commercial vehicle or not. If you want to establish that he's doing business, my lord, in such a case. So anyway, my lord, leaping about that issue, my lord, may not be very vital. But only thing is that the fact remains that he was in their association at the time when he was arrested. Now, my lord, if that be the thing, my lord, it is not that his arrest was, my lord, without any purpose or without, my lord, any availability of prima facie circumstances. It is not the case, my lord. It is not disputed. Now, my lord, lordship may kindly come to section 2, let's say, unlawful prevention of unlawful activities. Prevention of unlawful activities. Just see this. My lord, I may rely on this there. My lord, section 49 of the Unlawful Activities Prevention Act 1967. Not getting book.
Mr. Thapa, you want to make replies? You want to make replies to the
I'll make
anyway. Okay, then we'll conclude this part before we can reply tomorrow. Yes, let us see.
My lord, I'm almost, my lord, round about.
No, you just don't have to hurry. See, with Barasaji, you have to do
Which, my lord,
justice
only
to
a
your case.
question.
Yes. Unlawful Activities Prevention Act.
My lord, there is a huge difference.
And yes.
My lord, between a wrongful arrest,
Yes.
arrest which is apparently malafide, my lord, and my lord, the arrest which is made on the basis of the circumstances, my lord, companies. That distinction has to be there, my lord. Sorry, man, I should have given a list of books. I was under impression my friend is getting book. My lord, may I please section 14?
You don't have a copy.
No, my lord. Oh, we have.
Senior counsel
Only, but this is
preparing.
protection. My lord, this speaks about protection taken in good faith, my lord. 49A. My lord, here undisputedly that the accused was arrested under the provisions of
Yes.
Prevention of Unlawful Activities Act.
Yes, yeah.
So, my lord,
That's it.
that bars, my lord. My lord, until and unless he can show this is my lord. This is not his case, my lord. Now, my lord, coming to the proposition of follow in the Nambina's case and why it is not applicable. Now, my lord, here it's the case, my lord. Initial arrest by the state police, subsequent investigation by NIA. Now, NIA's investigation has not revealed anything with regard to wrongful arrest of the state. It is nowhere said the state has done it. Rather, they supported the arrest, only said that just because there is a deficiency of evidence at this stage, which may not be sufficient to prosecute, my lord, they have said that they could not do, but then have that thing which I have taken to your lordship. Now come to Nambina's case, my lord. They are very interesting. You will find, lordship will find, here the state, my lord, they assumed the investigation and subsequently it was to hand over to CBI, my lord. Now CBI there in their investigation said that the action by the police was totally wrong. Totally different factual background, my lord. Now kindly come to my lord Nambina's case, my lord, 2018-10 SCC, which my learned friend has referred to. Well, this originated from the arrest of 2 persons, foreigners, my lord, under the Foreigners Act, and from their integration it revealed that they are in possession of some secret documents, on the basis of which, my lord, state police went and, my lord, proceeded to take action against scientists, my lord. Subsequently, my lord, it was handed, trial was handed
There's
over.
a movie made
So,
out of this also. No.
There's a movie.
okay.
There's a
Yes.
I have not seen. Anyway, my lord, I'm just skipping paragraph number 2, 3, and 4, my lord. These are the initial facts. And then I'll start from paragraph 5, my lord. After the investigation, CBI submitted a report before the Chief Judicial Magistrate Ernakulam under section 173(2), stating that the evidence collected indicated that the allegations of espionage against the scientist as ISRO, including the appellant herein, were not proved and were found to be false, my lord. Where is the case? Here it is. This report was accepted by court's order dated 2/5/1996 and all the accused were discharged. That apart, in the next paragraph, my lord, in the said report addressed to the Chief Secretary, Government of Kerala, CBI respondent number 4 herein had categorically mentioned, notwithstanding the denial of the accused persons of their complicity, meticulous, sustained and painstaking investigation were launched by CBI and every bit of information allegedly given by the accused in their earlier statement to Kerala Police IB about the places of meetings for purposes of espionage activities, the possibility of passing on the drawing documents of various technologies, receipt of money as a consideration thereof, etc., we were gone into, but none of the information could be substantiated. Now, totally thing, my lord, which CBI report basically was a counter to the allegation of the state, my lord. Now, here not the case, my lord.
Yes.
Now, my lord, then paragraph 7 also, my lord. It's same thing almost, my lord, just only the last part of this paragraph, my lord. Paragraph Roman 5-6. C.B. Matthews and his team miserably failed even in conducting verification of the records of hotels, Fort Menors, Hotel Pankaj, so and so, were located in Trivandrum to ascertain the veracity of the statement of the accused persons. Now, my lord, it speaks about the inability and the wrong done by the state police, my lord, for which, my lord, a compensation was awarded. My lord, it is not that, my lord. So, this Minar's case, my lord, will not come here.
That is why Supreme Court passed out a fixed responsibility on those persons who conducted this investigation. That is why. And that's why, and the base of that, then compensation is awarded. And that is known, yes.
So, my lord, I'm just saying what I'm saying, my lord, I'm trying to distinguish this case from these things. My lord, this proposition will never apply, my lord. So, now, my lord, coming to the facts and situation when this petition was arrested, my lord. He was arrested on 13/5/2018. The petition was found to be an accomplice of the other co-accused, my lord, namely the Gaishing Meringmei and Sri Khamjang Rongmei, my lord, two of the prime accused in this cases, my lord. There is no denial, my lord. Now his statement, my lord, what you will find, that is at, my lord, page 34, my lord. Statement of the petitioner, page 34 of the affidavit of the NIA, my lord.
34.
Page 34, 34. Here, my lord, what my London President, he himself says that he was in company of those persons.
161 statement.
Yes, my lord.
Yes.
My lord, the second paragraph, I would also like to state that after my retirement, I bought a Rolls taxi, which my London friend has submitted, my lord. But then here he admits that, my lord, shall I go to, my lord?
Yes.
Yes. I would also like to state that after my retirement, I bought a tourist vehicle, Tata Sumo, bearing register number so and so, and the same was hired by Adhunik Cement Power Plant Company, is Jayantia Hills, in the rate of so and so per month, where I worked and stayed there for more than 1.5 years. After 1.5 years, I left the power plant company because my vehicle was deteriorating because of the bad road condition. I then sold my vehicle, the Tata Sumo vehicle number so and so, mentioned above, to 13 so and so of my village. I then decided to buy a Renault Kwid bearing registration number ML04C so and so from Mahindra Finance with down payment of such and such. I used to take my vehicle on hire for people of my community who live in my locality at Ladmukla and are in the business of selling clothes, to bring clothes from Shillong, Guwahati for selling in Joy. I was introduced to one so and so, my lord, that is the accused one. My brother-in-law, Sri so and so, is the accused number 2, my lord. In the month of March of 2018, accused number 2 is his brother-in-law, my lord, who introduced Sri Gaiching so and so to me as a railway contractor in Manipur. Gaiching had booked my vehicle for going to Silchar in the month of April 2018 for an amount of 5,000. Gaiching had also booked my car once for dropping from Guwahati rupees 4,000. Only on 13 February 2018, Gaiching had booked my vehicle for dropping him and his wife to a bus stand in Polo, Shillong, where his wife boarded 2 buses to Imphal, but Gaiching returned back to Ladmukla in my vehicle. He paid me rupees 1,000 so and so. I would also like to state that I had no idea of so and so. Now, my lord, it is not that on one occasion on that particular day, my lord, his vehicle was hired. Earlier he went to Silchar, he went to Guwahati, my lord. So they are in regular association.
Yes.
So, my lord, that shows, my lord, that yes, my lord, there was some materials which required him to be taken into custody, my lord. So it cannot be out of nothing, my lord. Like that Nambi case, my lord, where, my lord, the very initiation of my lord, investigation of the police was on the basis of statement of some other, my lord, accused who were arrested in other cases, my lord. Here it is not the case.
Yes.
So, my lord, I'll sum up by saying, my lord, this is not a case.
319, any other submission? 319?
My lord.
Any other submission? 319?
My lord, 319, my lord, I have already said, my lord. That is the till now, my lord, if any piece of evidence comes out, my lord, he can be, or even, my lord, even the because his discharge was at very initial stage, my lord. Not after, my lord, that the matter proceeded, because he was not made an accused at that point of time. Now, my lord, this 1990 judgment which he has relied on, that is with regard to a person who was an accused and discharged. This is an admitted case, my lord. He was not an accused, my lord. In the charge sheet, my lord, he was not made an accused. He has never been tried.
He was just a suspect.
My lord, in the charge sheet, my lord, there is a mention that there is no evidence. He was accused only in the FIR, my lord. But in the charge sheet has not, my lord, has not named him an accused. And at no point of time, my lord, he was tried as an accused, my lord. So that is very important.
Yes. Yes. Anything else?
So, my lord, I have sum up saying that, my lord, when this person was taken into custody, my lord, there was reasonable ground to believe.
Warranted some investigation.
Definitely, my lord. There is nothing on the record to show that he has been dragged from somewhere else. He has been falsely implicated here and all, my lord. It's nothing. His statement reveals that, my lord, he was in association with those persons, my lord. All right.
Yes. Anyone else?
I don't need to elaborate my submission. I'll just, because I was the complainant, I'll just show my role, why I file a complaint. If I'm pleased to take your lordship to affidavit filed by respondent number 5. Affidavit filed by respondent number 5. But I have stated in para 6. In affidavit filed by respondent number 5. You have 5, your lordship.
Yes.
If I'm pleased to read your lordship.
But it does.
Yes, your
Yes.
With regard to the statement, information was received.
Where are you reading from?
Para 6, your lordship.
Okay.
With regard to the the answer deponent state that the telephonic information was received from respondent on 13/5/2018, stating that as per intelligence agency report, some NSNK financial was operating somewhere in Clayton Sea, West Jante Hills. During the raid conducted by the team two persons, namely Sri such and such, were apprehended from the residence of Sri such and such at Mukla. The rented house of Sri Gaising was also raided, whereby found cash amounting to rupees 2 lakhs. Incriminating documents relating to the outfit, NSNK, SIM cards, mobile phone, etc. were recovered and accordingly seized. The apprehended such and such then led the police officers to another location, whereby the petitioner herein another person was found apprehended. It was on being led by the other co-accused person. Then the present petitioner has been arrested. After a preliminary interrogation, it was confirmed that the said insurgents belonged to the NSNK outfit and was involved in extortion. Several incriminating material, including cash, SIM card, and documents, were found and seized by the police officers from the premises. Therefore, the deponent filed a complaint on 14/5/2018 in the above matter. Then, if only that I'll read only para 7. Para 7. Then go to the fourth line of para 7. The petitioner was found to be an accomplice of Gai Singh Merengmai, Eli Ronald, and Sri Kamjang Rongmai. Two other accused were whom the petitioner had rented a house at Mukla in the same building. On preliminary interrogation, it was confirmed that the apprehended persons belonging to the NSNK insurgent outfit. It was also revealed that the petitioner herein had been facilitating the NSNK members by driving them to different locations in his vehicle. Moreover, it was revealed that the two members of the NSNK along with the petitioner had gone to drop the wife of the finance secretary of NSNK, Gai Singh Merengmai, at Shillong, along with the extortion money in the vehicles of the petitioner, and later they had a dinner together in the house of Kamjang Rongmai. Then furthermore, it is pertinent to mention here in that at the time of the petitioner's arrest, his name was mentioned by finance secretary that he is also part of extortion groups. So this is the reason why he has been apprehended. He was not apprehended merely, he was not just picked up, but his name was mentioned, and on being led by the other two accused persons, he had been apprehended on the ground that he has been taking part in extortion and he has been facilitating for dropping the accused from one place to another place. So this is not just a commercial, but it is the hand in glove in the extortion case, Your Lordship. So this is the reason why we filed an FIR and he has been subsequently arrested. Yes, and later on, the case has been handed over by taken over by NIA. This is my limited submission.
Yes, Mr. Dr. Mazika. Yes, we'll let him reply tomorrow. Let us prepare himself. Yes.
Should I conduct tomorrow?
No, how long will it take?
5-10 minutes. Well, only three aspects the learned additional advocate general has referred to my affidavit, my lord.
Yes.
Para 13, my lord, of my affidavit.
1 second. Yes.
Well, this has been read. I'll read once again, Madam, just for reference. During the course of investigation of the instant case, it has been revealed that accused petitioner so and so, alias Benjamin, owns a Renault Kwid having a registration number ML04C so and so, which was hired by the main conspirator in the instant case, namely Kai Chung-lung Merengmai, alias Gai Singh, alias Ronald, alias Nelson, alias Kevin, before commission of crime. During and even after the commission of crime, the details of the vehicle purchased by the accused petitioner, Mr. So-and-so, was also verified from the RTO office. The accused petitioner, Thuangpang Benjamin, was arrested along with the other accused of Meghalaya police, even after extortion of rupees 25 lakh from the BIPL company in turn of releasing abducted employee of the company on 13/5/2018. Gai Chung-lung Merengmai so-and-so, the main conspirator, went by the above mentioned car driven by the accused petitioner so-and-so from Joy to Shillong to drop Mrs. so-and-so, wife of the accused Gai Chung-lung Merengmai, who was carrying rupees 13 lakhs out of the extorted money. Therefore, it was prime responsibility of the NIA to unearth the entire conspiracy and to ascertain the involvement of the Benjamin in the instant case. The CDR and CDR analysis report of the mobile numbers of Thongpong's petitioner, my lord, and accused A1 established that Thongpong was in regular contact with the main accused A1, my lord. My lord, we annex the CDR and we also annex the analysis of call data reports, my lord, which indicate that they were in constant touch, my lord, with the main accused. So, my lord, in my humble submission, on the basis of this, there was a sufficient material for NIA, my lord. My lord, they are trying to make out a case of malice, my lord. Malice is prosecution or malice is arrest, my lord. In my humble submission, when such material is available, my lord.
Yes.
And that coupled with another fact that one Benjamin is also arms supplier to NSC, my lord.
Yes.
Now, para 11 has some relevance with regard to the identity of Benjamin, my lord.
We can leave that aside, doesn't matter. See, the only thing is that what the court's concern is whether the investigation or whether the being in custody is based on any cogent kind of materials. That is all. So that will warrant investigation. Is it a question of someone being picked up on the street, subjected to torture or something when there's no there is no what do you call it, a nexus with any incident that happened. In cases such as those, then maybe the court has looked at the amounts of police brutality and excess of use of force. So those are different matters.
Moreover, my lord, the case of malice, my lord, where is the malice? The investigation has been so fair that at the time of submission of charge sheet, the NIA itself is saying that after investigation it transpires that.
No, the basis of the whole case is there just by association that he was not the knowledge, he didn't know. He might be having dinner with them, so how do you know?
So that's what, but NIA
what's going on in the
NIA was very fair, my lord, at the time of submission of the charge sheet. It was not a case that unnecessarily we were trying to rope in again or charge sheet in the charge sheet, my lord.
Yes. That's it.
So, my lord, there are two provisions. One provision has been cited by additional AG, my lord.
Yes.
Section 48 of the Section 18 of the NIA Act also, my lord. I have annexed that, my lord, in the counter affidavit.
Where?
At the end, my lord, last page.
Of the affidavit?
Of the counter affidavit. Section 18, page 167. Sanction for prosecution. No prosecution suit or other legal proceedings shall be instituted.
Where is that?
Section 18.
Yes, okay.
No prosecution suit or other legal proceedings shall be instituted in any court of law except with the previous sanction of the central government against any member of the agency or any person acting on this behalf in respect of it done or purported to be done in exercise of powers conferred by this act. Now, Section 49 of the unlawful protection of action taken in good faith, my lord.
Yes.
In my humble submission, the entire action was in good faith, my lord. There is the element of malice they have to establish, my lord.
Yes.
In the facts and circumstances of the case, there is no element of malice, my lord. In fact, the investigation was so fair that after we didn't find, we have disclosed in the charge sheet that, and on the basis of that, our report, my lord, he was released, discharged from the case.
That's it?
Yes.
You reply tomorrow, we'll feel it tomorrow. Yes, sir. Further in part, this will clear further here. Tomorrow is 15th. Yes. Bring some authority to public law remedy.
Thank you.